one nation, under God, indivisible, with liberty and justice for all.
Julia, I believe we have a quorum, is that correct?
We do.
Okay, we'll proceed. Judy, I heard is about 10 minutes out. But
Yes.
we've decided just to go ahead and do some of the preliminaries
Yeah,
before she joins us.
if we could start the call roll, if we can.
Okay,
Vice Chair Burdick,
present.
Mr. Graham Williams,
Here.
Mr. Sorensen,
Here.
Mr. Weiss.
Here.
and Chair Stern is absent, but you have.
Okay, the first order of business is approval of the May 4th and June 1st, 2023 meetings. Let's start with May 4th. Does anybody have any comments? Anybody wish to move in? Second? Any seconds?
Second.
Oh, okay.
Mhm.
Okay, all in favor?
Aye.
Any opposed? Okay, let's go on to the June 1st, 2023 meeting minutes. Do I have any comments?
Yeah. Chair, I had a couple questions, just want to close the loop on. Let me see, page 4, let's see, third paragraph down, page 4, June 1st. Mr. Weiss noted that this section was written roughly 40 years ago and asked if the board felt the $5,000 limit should be raised, considering this has been an issue for past city administrations. So I think worthwhile bringing up. I don't know if we had an actual decision on that, though. Not seeing anything in there. Do we want to have a decision on that?
Do we, anybody want to make a motion?
Maybe we put it on old business or something.
Put it on old
Add it
business.
to the- Add it in the agenda.
Yep, that's fine. I'll make a note of that.
Which section is that?
8.01. And that was just a question, how, when we have items like this, just making sure that we're somehow putting it, making sure we're gonna decide about it to build into whatever our document is. Okay, that was one. And then this was, Attorney Bengal mentioned, see, no specific terms and notice to bidders. Are we gonna change this? Do we want to kind of have notice to bidders? So that's another question with that.
What issue with section?
Same thing, basically saying Mr. Weiss also felt this section is written in a confusing manner as it does not specify terms such as notice to bidders. So do we want to clarify that? We want to leave it as it is. If we do want to clarify, great. So that's just same plot place for old business is fine. There. Yep, that's it. Sure. Thank you.
Okay, with the notations, anybody wish to move the minutes?
I'll move. I'll second.
Okay, all in favor?
Aye.
Opposed? Move.
Just, I did want, if you don't mind, I'd like to address this comment. My concept that I would like to put forward is that at some point, I mean, I know that there were these hot button issues. I know everybody wanted to discuss them. So, but at some point, I think we need to move through this charter section by section. And so my suggestion is that when we get to section 8, like you had some questions about, that we then have a full discussion about section 8. Two things. Number one, it sort of gives us a beginning and end. And also in terms of the public, they know that on a particular time, we're going to be talking about sale of city property and stuff like that, and they can get their comments prepared and stuff. So that's what I'm going to urge the chair to do when she gets here, which is, I mean, I think we've gotten through these hot button issues. We got through the ethics, we got through we're not done with the measure, but we've gotten through the land issue. We talked about it. Now we're talking about the election issue. It was a third sort of hot issue that we want to. But, starting maybe the next meeting to start having old business on these other items, but to start to walk through the charter. Otherwise, they're just, I just feel like it makes sense to march through this thing as opposed to like, hey, I'm thinking about this.
I agree.
I agree too. I think in the beginning, we wanted to first address some of these hot button issues. But I agree with you. I think then we go back and start at square one and address them. And I recognize that last time we addressed a lot of these issues, but I don't think we brought a lot of resolution to any of them.
Right.
And I believe tonight we do have at least a follow-ups on the prior meeting. And why don't I ask Paul? If you prepare some of those follow-ups for us to.
Yeah, if I could just stick my nose in one more time. The first button, Judy's excellent at getting this agenda prepared. And I've tried to give her input, the list of just sort of general charter sections that needs to be revised. I think we need to keep sort of on the side. And so as we go through section by section by section, we deal with those things as opposed to just going through a list of charter sections that need to be revised, because we have the list, we can say, oh, for the city attorney office things, we're on section 6, let's deal with that stuff. And so I'm not sure, I probably just did it too fast or on my phone. I don't know how this particular item got on the agenda, but we have it. And so I'm going to suggest that we just keep it on the side. They've done their work, but they've done what we asked them to do. And then when we get to section 1, if there's things that in the city attorney's office things that we need to deal with, let's deal with them as opposed to just sort of dealing with their list. I don't know if that makes sense.
Agreed.
That makes sense.
What section were you talking about? then?
I'm just like, see where it's this list of charter sections suggested for revision.
Mhm.
That's their overall work that they've done, and Paul's done a good job on. And that's the one which is sort of a catch on. I mean, there's things.
No, I don't want to interrupt.
That was just a sort of a list of everything they thought needed to be done. So that's a section. I must have skipped. It was Junior's perfect. And so I must have missed it when we went over it, but I don't know why that's even there for the moment.
That was a list that Alan had kept.
That's this,
Yeah.
Yeah.
Yeah, I think we should.
That was a running list that Alan had kept. I also had a few items also. I was keeping a list as
Yeah.
well
I think
as we went along and.
just deal with them as we go through each
Yeah.
section.
Well, some of the hot button issues that
They're on
I
there.
think are here that aren't. In addition, I think, Paul, you said you had some, I have 3.04 talking about qualifications. And 3.09, some of the things that occurred for this last election that I think we should at least discuss.
You wanted, when we get to the section, or is it?
Well, I think that was tonight. We
Yeah,
were
we
supposed
can
to
talk
talk
about
about
it, yeah,
elections.
elections.
Yep.
So
Yes,
I prepared drafts of various sections regarding the property and elections with.
It's here a little bit further down. So the first item was just to talk about the legal opinion issue. Dealing with the lobbyists serving on city boards.
And you summarized it so well a moment ago. Yes, I answered a slight variation from, if you want.
no, please, yeah,
I answered a slight variation from what actually appears on the agenda. And the question is, I understood it, was whether 2-264 applies to board members. And then I went through the history, and 2-264 is the section about elected commissioners and certain employees not being able to lobby for a certain period of time after completion of the service. So if you don't mind, I'll just read my conclusion.
please do. All right, I'm turning it over, the gavel over to Judy.
Oh, I
He's
was
not
hoping
here.
you would continue.
I know.
Okay.
So,
Excuse me, Paul, for the record, can you just say that you're here instead?
yes. Judith Stern and I am here at
Thank you.
5:37,
Thank you.
38.
So the heading or catch line of section 2-264 says lobbying by former city commissioners, board members, and employees. Prohibition. So the question, as I understood it, was whether that actually applied to advisory board members. My answer is no, and for various reasons. First of all, they're not mentioned in the text of that section. And so that heading is merely a catch line, and so I'll leave it with conclusion. Although the catch line for section 2-264 of Code of Ordinances of the City of Fort Lauderdale, Florida, mentions board members, and there was some discussion by the City Commission of applicability to board members. You'll see that in the minutes that I attached. Inasmuch as section catch lines are mere catchwords to indicate the contents of the section and are not titles of such sections or any part of the section, and there's no mention of board members in the section text, it is my opinion that section 2-264 does not apply to members of city advisory committees.
And I think that's pretty well consistent with past. Past performance. I mean, when you look at the board members to all the different advisory boards. And then you should know this because you've appointed lobbyists to boards. That this has never been an issue before, so I don't know why it all of a sudden became even a question for a waste of, discussion.
Sure, yeah, well,
And-
actually,
and
no, go ahead.
you've appointed lobbyists to boards,
Sure, so
and so is Steve Glassman and Dean, so.
as you probably know, it's one commissioner can appoint that board, right? So you make it, it's actually voted on by the city commission, right, collectively. So the city commission has definitely appointed lobbyists.
Well, I mean, there were minutes that actually reflect you and Steve Glassman jointly appointed someone. So you've all done that. So let's move on to real business.
Well, I think this is worth, I think there's worthwhile discussion about this. A lot of, I don't know if you all have, heard it, but there's a lot of interest from the public about this topic and,
The only
lobbyists.
people that I've heard about from this topic has been you
Oh, okay.
and then Steve Glassman. It has not been from the public, it's never been submitted to us. We've been meeting for, well, Chris, you were on charter review. I've been on charter review until you guys suspended charter review for years. And it's never been an issue until you and Glassman created this issue. So I think that we really need to spend time talking about issues because Nate is here. And I know he has a timeline.
So I think there has been some public input. I think, Junia, have you gotten any public feedback on this lobbyist?
I have not through the commissioner's office. I don't recall.
Through the email, the charter revision board? email?
I don't recall.
Okay, because I've gotten some emails and.
I'm sure you have from your followers, that you communicate with, which we're all familiar with. So,
Sure.
I think it's much more important. And all the prior charters always had public participation, public input, and it's never been an issue. And Richard's been on the charter review at the county numerous times, and it's never been an issue. So.
Do you want to see if any public have any issues?
Oh, well, I'm
or-
sure you have someone here. I see that at every meeting. So you got two people right here. So do you want them to speak? Because those are your people, so,
They're not my people.
well, they
Judy.
are, so,
I'm a big believer in community, Judy, and a big city with stakeholders all being involved and engaged. And I think it might be good to hear
actually, you
from.
haven't actually done that. So we have public input at a later section. So I think let's
Okay.
deal with
Whatever you like. however you
I
like
think
to-
so.
But can I just jump in? I'm listening to the both of you. That was also listening to Richard. When we come to that section in our general review, maybe that would be the time that we insert. Do we as a charter revision board recommend a change in the policy? If that pleases, the board and or the public input. So.
Yeah, and absolutely, and I think this is, because it's on the agenda, I think this would be the right time to at least hear from the public at some
Well,
point
it's
in the
not.
meeting.
Right,
whenever-
later on, we
Yeah,
have
later on,
public input. And
absolutely.
we've had public input at every meeting
Which is great.
and no one's ever brought up. So let's stick with our speaker.
Yeah, no, I think
And
that's
let's
great.
just jump over because
Yeah.
our speaker is on the timeline, which
Sure.
was kind enough to tell me. And the reason why, so the public understands, the reason why we have Nate here is he is the expert on the election laws and redistricting.
Sure.
And it was two issues that really were mishandled here at the city last year by the ordinances. And we went through a debacle because the city's ordinances that you voted on were incorrect and inconsistent with law. So they, I'm going to turn that over to you if you want to start first with the process. You want to start with redistricting process
Okay,
because
sure.
that was a very hot topic for you.
Absolutely. So, in 2022, we went through at the Supervisor of Elections Office, the redistricting and re-precincting of the entire county as a result of the 2020 census. And supervisor went out to each city, said that if you're going to be making changes to any districts that you have pursuant to your charters, timeline is important because we need to get input from all of the cities regarding their districts, because when we're setting precincts, because there has to be one, a polling place in every precinct. And we have to utilize other political boundaries that are being set. I know that there was communication between, and I don't know with whom at the city. I know that there had been a lot of communication early in 2022 about a pretty tight time frame, because if everybody remembers, the census results came out very late for the 2020 census. So everybody was scrambling from the Florida legislature and what they decided to do with regards to various districts, to the county commission, who went with FIU as an independent body to help establish the county commission districts, the school board, everyone else. There was a lot of, since we have to get ballots prepared, we have to get precinct agreements signed with each of the polling places, because a lot of them are private locations. Fort Lauderdale was one of the later, if not the latest, in terms of getting us precinct information now, or to me, district information. I'm not particularly familiar with how you all went about your process in terms of establishing your districts. I did look at the charter and the ordinances that relate to that just very briefly in advance of this meeting. So, and I don't want to opine on policy because I'm not a policymaker on this. So from a legal sufficiency standpoint, your districting ordinances and provisions all are legally sufficient. But they don't provide for any particular time period and a tight time frame in terms of being able to get that done and get that to the supervisor of elections, knowing that he is going or she is going to be creating precincts based on that information. So I was asked to comment a little bit about that. I know that we didn't get them until I think May, and which created a lot of problems. So in terms of the precincts that were established were delayed, and then they had to be redone again one further time to make some changes between the August and the November election to address certain issues, including a few that were in Fort Lauderdale.
And what did happen was the city started around the same time as the county. The county had done a charter change. Richard, you were probably on the charter with that, so that only educational institutions could be selected. If you could explain that.
That change was made so that it wasn't a political process, that some established expert who knew the legal criteria for establishing the district would advise the county commission on the district. And so we felt like it was important to have, sort of an independent, sort of academic kind of review of those districts. And that's why it was.
And most of the other cities in the county adopted the same policy that the county did, because the voters voted for it. And most people assume when the voters vote on something on the county, it then rolls down to the cities. Unfortunately, what the city had done, which created all the delays, was they hired a commercial litigation firm and had them looking at Born Learner, etc.
For this past one? FAU did the last.
They did it, but first they had Robert Vaughn's law firm, and the city commission then deferred Because that was the recommendation from the city clerk and city manager's office and the city attorney's office. And that got delayed until January, I think, is when they started then changing it. And it was recommended that they look and piggyback off the county's process. Did you use
We
FAU?
use FIU.
FIU.
Right, and I also, just as an aside, I serve on the charter review board for my city. Up in Parkland, and obviously Parkland and Fort Lauderdale are very different beasts in terms of all of these things, but. I know from the process that we have up there, there is a very small universe of the experts that are out there that do districting. There are a few commercial consultants that are proficient in the field. But otherwise you're stuck with, or let's say stuck with, otherwise you're looking at the political science departments of various universities. I know that you went, in terms of the county's process, we had UF, FAU, and FIU that all submitted proposals. And the county attorney's office actually was the party that was charged with evaluating those, making recommendations in terms of the selection of a particular outfit to handle it. It turned out to be FIU. And I think a couple of cities piggybacked off that contract. And I know that not only was that for the redistricting process, the supervisor of elections office actually piggybacked off that contract to have FIU prepare the maps, precinct maps that were then voted on by.
And they had all the data already done, finished from the county. And the questions started rising at the city, why are they hiring a litigation firm who actually sued unsuccessfully the county in the past of a redistricting? Why would the city choose them? And eventually it got kicked out and reconsidered. So that was like a 3-month delay. I think it was January or February when they switched over.
I can't speak to any of that
Yeah.
part of it, but I know the end was a lot of frantic communications from the supervisor's office to the city saying, is there going to be a map voted on and when, so that we can utilize that to help finalize the precincts.
So, and in the past, this issue came up when Harry Stewart was the attorney here. And Rochelle Golub was on the charter review at the time, and she asked about the redistricting process, and the decision was we didn't have to deal with it because it was something that was automatically done every 10 years. So this is the first time it became a hot issue over process. And that was, it really created a lot of delays as far as what the district lines were versus the county is, they kept calling the city wanting to know the update. So I don't know if there's something we need to look at as far as putting a parameter in for the process or.
Paul, I don't know if are you on this?
I wasn't involved in that,
Now, are you up to date on what the city charter and the city code say about this?
not really,
It's just,
on redistrict.
yeah, on districting is section 712 of your charter. I did not look at the ordinances regarding this. You know, your charter provision provides that, you know, provided for the original districting that took place, I think, back in '87. And then provides for, after receipt of the most recent published information, which is decennial census, the city commission establishes the boundaries of the 4 commission districts. There's nothing in your charter in terms of who assists or anything else along those lines, and I certainly wouldn't make any recommendation one way or another in terms of that. That's obviously for you all as an advisory board and then for your commission to determine whether or not they want to have something about.
The difference between the precinct issue and the district issue. Generally, charters deal with what this charter is, which is the district issue, and the rest is really where people vote, right?
Right, the rest flows from the timing of your districts help then allow for the timing of the setting up the precincts.
there anything in the charter around redistricting you think that we should improve on or add or
I wouldn't,
gaps there?
wearing my lawyer hat for both the supervisor and for the county, I have no opinion on policy with regards to that. You know, you do have, you have nothing in terms of who assists the city, which is different, obviously, than what the county has in terms of what had been voted on by the voters in connection with that. That certainly could be something that is adopted by ordinance rather than a charter provision in terms of who assists with the redistricting and any particular timeframe. There are two ways to skin that.
And with the county, what does it specify academic institution?
I believe that it says something along the lines of a public academic institution.
Or your
Yeah.
public institution, okay. And then does it
Richard, do
give,
you remember when that,
I don't remember it.
but it was very clear and the voters voted on overwhelmingly to support that educational institutions.
I wouldn't be held to it, but I think it might have been back in like 2008, because I remember
Yeah.
that in 2010, there was a big back and forth in terms of, or after the 2010 census, there was a big back and forth regarding how that would be applied.
and what's okay, so that's an opportunity for us to possibly look at including, it. And then the timeline you mentioned.
That would be by,
What's in the county?
oh, we don't have anything, but that certainly could be done by ordinance or even by internal policy rather than, I always view charters, especially since I serve on a charter review board, as, your skeleton, your constitution, not getting into the nuts and bolts of daily operation. Because you may need to change things on the fly and you have no ability to do that if it's in your charter. But certainly all of those things can be done by internal policy or by ordinance in terms of timeframes or who assists or who can't assist. Those kinds of things.
Not asking you to opine in this official role, but incidentally, has the City of Parkland Charter Review Board taken up this issue?
Absolutely not.
Okay.
We have by ordinance, a process for redistricting. And after every cycle, actually, we do it, I think we do it every 4 years, which is a lot. A lot. The reason that Parkland has had to do that is because we have a requirement for population equality amongst all of the districts, and Parkland has been growing exponentially. And if we did it every 10 years, you would have all of West Parkland, would suddenly have a huge population imbalance with the rest of the city, since that's where all the development was happening. I'm sure that, I've asked in our current charter review, I've asked our city attorney from Weiss Serota to come up with, or at least have a discussion when we get to that provision of the charter, whether or not we should be going to a, every 10-year redistricting process, since we're sort of close to that build out at this point. Every 4 years system.
So I really think that where we, based on what your comments are, is looking at just a recommendation for the city attorney to discuss with the city about an ordinance to follow suit with what the voters voted on for the county charter change. Because of that really created a big debacle here.
I think the issue really is, for me, whether there's nothing wrong with the charter. It works. In this particular case, the city commission decided to hire a different. So the question for me is whether we want to impose on the city commission the obligation to hire, to sort of specify who's gonna advise, or whether we want to leave that to the city commission and let them decide. That's really, I think in terms of charter review, that's to me the only issue. Maybe there's other issues, but I don't see any other issues on this particular thing, so I don't know what the pleasure.
But I think the problem was just because, and Nate called on a few occasions, who at the city would get this moving because of the delay and hardship that created for the supervisor of elections in the following precinct.
That's honestly on the city commission. They need to, we have to assume that they're gonna do their jobs, and we can't write a charter assuming they're not gonna do their jobs and try to cover every single thing that they think they should. So it's big parameters that the charter should include.
If we are going to continue discussing section 712, which I don't think was the intention, given that we have a broader elections conversation, there is something critical to this that I would like to discuss, which is the number of districts. I would also like to put a pin in that for a future meeting.
Judy, what we discussed before we weren't here, I hope it's okay with you, is that we hit a sort of hot button. Regulating the elections and public policy on property, ethics, stuff like that. You sort of had a consensus, I think, that after this meeting, we would start from section 1 and say, like, in this next meeting, we're going to discuss sections 1 and 2. And then on all these issues that have come up, like just brought up, or just like the issues in section 8 that we were just discussing before you here, we would discuss those in the process of doing that. We don't want to lose track of them because they're important, but it would sort of give us some sort of structure, if that's okay.
That'd be great. And the issue with the elections and, you know, while Nate is here and the issue that was created last year was when we finished the last charter, we thought we would be reconvening after 2018 so that we'd start looking into staggered terms, seating. And when it came to the attention that the city was inconsistent with the law and about the timing of the November elections, when people get sworn in, I did send emails over trying to get the charter reconvened, and it was rejected. And it was never called, and I had at least three different communications going, requesting it because of the conflicts. And changing to November, the way with primaries, changing to November, and the midterm change when you can get sworn in. So if you want to
Right.
expound
So,
upon that.
A couple of different things. The way that, the special act reads in terms of the municipal elections and them being certified within 5 by the Broward County Canvassing Board, who is the canvasser of your elections. Traditionally, under general law, each city is responsible for holding their own municipal elections, for canvassing their own elections. The city clerk is the filing officer. As a result of that 1975 special act and all of the subsequent amendments to it, it's the county canvassing board that does that. Because you have November elections, there's two sort of unique circumstances. In November elections, the time period for certain overseas voters and for the service members that are serving overseas, as well as any U.S. citizen who happens to be a voter in Fort Lauderdale or anywhere in the state, have until 10 days after the election, 5 p.m. on the 10th day after the election, for their ballots, which had to be mailed no later than election day, to be received by the supervisor of elections. Now, you could certainly have circumstances where those last remaining ballots may come in and change the result of an election. So we were asked, at the supervisor's office, we know how many outstanding overseas ballots, may exist. So in certain circumstances, the canvassing board has the ability to say, okay, this election, I remember there was one particular city election where I think one candidate got 2 votes in a particular city. We knew that there were not enough outstanding ballots that could potentially impact that race. So the canvassing board does have the ability to, when it's doing its first officials or certified results, to issue some certification. But by law, the final certified results of the election don't take place until at least 10 days after. So having your charter, address, again, I haven't looked into it in terms of what I would recommend drafting, nor would I make such a recommendation. You have very capable counsel, and you as a policy making body or a policy advising body, having tracking more to the language of the Florida election code in terms of when it is that your members are seated, when it is the certified results are. Excuse me. I know from information that I received from the city that there's a recommendation relating to section 3.04 of your charter, getting rid of the provision that talks about the city commission being the arbiter of elections, which, by the way, happens to be what U.S. Congress and the U.S. Senate and the Florida legislature have. Those bodies are the judge of their own elections. Which is why you can't file an election contest for for a congressional seat, a Senate seat, or a Florida legislative seat. The federal, Congress has a Federal Elections Challenge Act that it has established to provide for challenges, because otherwise you're making a petition to the Speaker of the House and the President of the Senate to have an election challenge, which would be probably not workable under any circumstances, let alone the current situation in Washington. So I know there is that recommendation in terms of moving that and following along with chapter 102.168, which is the Florida election contest statute. That's the method by which all election contests that I've ever been involved in are resolved. Unfortunately, I've had to be involved in too many of them. But I know that's one of the recommendations. There was also something else that was just purely because I was reading and not as a result of anything else, is that you have, with reference to and this only sort of drew my attention because we had vacancies on the county commission in the last few years, and how those get filled and for what time period and when it goes before the voters again. You have reference throughout your charter to quadrennial municipal elections based on 2020. So technically, how your charter reads is your 4-year elections happen in the presidential election cycle. And I saw in 7.08, and I just bring this to your attention for however you want to deal with it or not, is that you have a provision that says when there's a vacancy or vacancies in the office of city commissioners, when it's less than 18 months before the next regular quadrennial municipal election, it gets filled by appointment by the rest of your commission. And that is something that exists in a number of charters in Broward County. But you also have a provision that calls for special elections if it is more than 18 months or more before the next quadrennial municipal election. Now, as we saw from the vacancies on the county commission, when there's more than 28 months between the resignation effective date or the vacancy effective date and then when that term would otherwise expire, it gets put onto the next general election. So you may want to consider, and I just bring this up for however you all want to deal with it or not, dealing with that quadrennial municipal election situation rather than placing it in the next general election, which would happen in the your 2022s, your 2026s and whatnot, rather than having to call for special election. And I say this as the supervisor of elections council, knowing how much it costs a city to hold a special election. When you're holding an election, when there is a countywide election happening, the potential costs to the city are significantly less than if there would had to be a special election call. You also have the benefit of early voting. You have the benefit of that additional time period for your overseas military voters to get their ballots back. And you're not paying, you're paying the incremental increased cost for certain things rather than, okay, you're holding your own election. Therefore, the entire ballot, all of the postage going out, all of the postage coming back in, all of the staffing for the dozens upon dozens of precincts that Fort Lauderdale has. And then being selfish for a moment, for the supervisor, given the requirements on the supervisor's office during off years and off periods now that have been imposed by the Florida legislature in their wisdom, holding a special election becomes extraordinarily disruptive. And there are circumstances where the supervisor says, we don't have the ability to schedule this. We had a request made by a city, hey, we'd like to have our special, we have a vacancy, we'd like to have a special election 3 weeks after the March municipal elections, to which the supervisor said, yeah, I can't do it. You either need to be on the existing more broad election or not.
I know you're not doing policy, but you're suggesting as an option that instead of having the vacancy filled by special election, it would be special election conducted in conjunction with the next general election, which could well be before the 4 years.
Exactly, and then you have that individual fill out the remaining term, just like we had with Commissioner Holness's.
So it's a special election, but it's just held in conjunction
with a countywide election.
with another campaign. So just to understand it, so we're on a 4-year cycle. You're saying there's other elections in between
The quadrennial
Right,
for
right.
presidential.
that we can piggyback off of those. And that would solve the problem of having an appointed commissioner work for be there for such a long time, but also be economical because we would do it in conjunction with another.
Yes.
Which is really why the three that resigned. Did it effectively, originally Ben was going to do January until his colleagues saw the expense for his seat to be separate from the others, and they didn't want that burden on them, the financial burden. But everyone else did it effective November so that the new people could be running on the November ballot. So that's when the colleagues
you
got
also
that to
said-
change his thing from January back to November.
Yeah.
And Glassman,
And
you know,
technically, that was a
Very upset about that.
special election called
In
in conjunction with, but your charter doesn't require that. It could potentially have a situation where
Right.
you haven't, you'd like, hey, we'd like to have an election in April or May, which is particularly disruptive and expensive.
yes.
That's a really good point. Let me just provide this by way of explanation. As everyone recalls, the last charter amendments were limited. There were only certain things that the state commission authorized to go onto the ballot. And changing the election from March to November and making it every 4 years. Pretty much what we did was change the word triennial to quadrennial. Because it used to say triennial. So
But they
that,
did, right, and
but
that
we
was when I reached out to Alan, trying to bring to his attention that the rest of the substance was not changed to be consistent with the quadrennial.
and we didn't address, we weren't directed, we didn't address the 18-month rule, we didn't, there were limited things that we were.
And this is, and I know I'm stepping way out of my, because I literally was just, when I saw what the agenda was tonight, I went and printed out your charter, searched for things like primary election and vacancies and things like that, just because we had dealt with them recently. In case it could be of any value to you all. I have not discussed this with anybody before showing up.
I don't know if it was any easier or any better with it. Just time-wise, in the 18-month rule. With it being triennial, I don't know if that makes.
Only because, the only reason that I can think that. And
They
a rank
just did not
speculation
change to
was
make it
when you had
consistent.
triennial, 18 months is half
Right.
of an election. Or half of a term of office, and if it was more than half of a term of office left, you would hold your special election. If it was less than half of the term of office, you'd appoint a replacement member for the remainder of the term.
And the fact that in March elections, when you could be as certified versus November elections, it's a different certification date.
Sure.
And that was the other point that we kept on trying to reach out to Alan to bring to his attention that was rejected. So those were the inconsistencies that created so much of the.
Let me ask, someone asked me, could the regular quadrennial election be in August for the city?
No.
Okay.
By
Is their
special act,
question
it's
was-
no, it's
Like,
November.
always have to wait, because they were asking me, could it be in August, and then if
Yeah,
there's
they
not.
addressed that a couple
Yeah.
meetings ago.
And if there's not a plurality.
No,
you're saying always
Absolutely
have to be
not.
November.
There, if you have, there are no primary, by special act, in the state of Florida, there are no primary elections for your municipal elections for elections that are going to occur in for your November. Right.
But I think we make things up. Very good
That's
point.
great.
My suggestion is that we think about what he's talked about, that we reserve the right to call you back if you don't mind. But as we start to go through these, because there's a bunch of issues dealing with elections. Is 18 months right? Is it too long? Is it too short? What about the special election? There's a bunch of things.
And the staggered terms.
With staggered terms, that's a whole, that's a whole discussion. Should there be more districts, less districts? At large, all that stuff, none of which I have an opinion on, honestly, but they're all things that we could discuss. And I think that we should just say thank you, unless you have something else, and put this, when we discuss the election section, have a real discussion about all these issues and, put them, and then make some decisions. That makes sense.
Richard, when you said when we get to the election section, that is something that I thought we were going to address tonight. So
I'm happy, listen, I'm happy, I just am, if you want to discuss, but there's a lot in the election section that we haven't even talked about. But we can talk
right, no,
about it.
I understand. I was just asking for clarification.
No, I'll do it, I'm happy to do it any way you want, I don't have a strong opinion, but I'm just trying to organize so we're not. I thought we were gonna have a presentation, if we want to make some decisions tonight, that's great.
Well, I'm not certain making decisions, but there were some hot button issues that occurred in the live election. And one of them was touched upon at 3.04. We'll go into that. Judge of elections and qualifications of members. And in this section, it said any registered elector in the city of Fort Lauderdale shall be entitled to file with the city commission an affidavit setting out facts showing that a candidate has violated the provisions of this charter and as to the manner. But that is done at the time the city commission meets with the canvass board to go over the results of the election, which really had set up, a sense of, if you're a loser in the election, then you can challenge. And I think to avoid that issues that we went through, that we should consider moving that challenge date if we're going to keep that, prior to the election itself. So we don't go, first of all, go through an entire election cycle with a candidate who could be disqualified. And it brings more order because this, yes.
Do you remember the judicial races? I think it was Marty Lee Cone and Pedro de Hollis. And Bill Scherer filed the challenge after the fact, and the
Right.
state ruled if you're going to raise the issue, you raise it prior to the election, not after the outcome.
From having been a candidate against Miss Levy Cohen in 2010, I remember the 2008 election very, very clearly. So, and as we all know what happened with that one, because I'm here. So, yeah, me too, I'll stay at this point. Silver linings. So there are a couple of things, and I only say this because I've had to litigate probably a dozen or more both election contest, post-election, as well as election qualification, pre-election. Now, Florida law already has, and again, your charter specifies a manner and process by which you're limiting the way that somebody can go and challenge an election or challenge the qualification of a candidate. So under Florida law, anybody can file a lawsuit pre-election challenging the qualification of a candidate to run or serve. Post-election challenges, which have to be filed within 10 days after the final certification of the vote. And it is a very limited process in terms of the 102-168 challenge, which is the election contest statute. That is challenging the eligibility of the individual to serve. So there's a difference in terms of qualification as a candidate, eligibility to serve. There's some case law out of the 3rd district in South Florida and a few other district courts of appeal that really delineate when you can make certain challenges. That you cannot make a challenge to the qualification of an individual as a candidate in a post-election contest of election. You're now dealing with eligibility to serve rather than qualification as a candidate. So things like the oath wasn't done properly when they were signing their oath in terms of to qualify as a candidate. I believe there's a case out of the 3rd district, which is Miami-Dade County and the Keys, that actually deals with residency. And that was a challenge to the qualification of the individual to run rather than eligibility to serve, because that individual would have resided in the district or in the city for the requisite period of time that the term of office began. So I have zero opinion on in terms of this particular issue. I just would point out that there's already a process under state law, both for challenging qualification of a candidate pre-election and challenging eligibility or discrepancies in how the election was canvassed post-election.
And the other issue we had was the affidavits that we utilized in the challenge were not correct. And you have to state in an affidavit that you have knowledge that's factually correct. And the affidavits that were filed, so it should have been rejected on its face by the city attorney immediately because there was no factual correct statements in it. And actually, the Marty Cares office provided the information from their attorneys that it was not factually correct and they were notified. But they chose, the city chose to keep the challenge alive, even though it was not legally sufficient on its face.
And I'd also, one other very brief thing, add that the post-election challenge, contest of election under chapter 102, 168 is an expedited process. So we've had circumstances where an election challenge is filed within the 10 days. And within another 3 weeks, you have your evidentiary hearing and decision.
Hey, I'm not that familiar with that section. Could you spend a little more, does it cover, the thing that I feel, the first time I'm gonna say this thing I feel strongly about is I feel like the whole idea in the charter of the city commission is in charge of qualification of its members is terrible. My default position is, however you get there, is that the court should decide this. And if there's a issue of qualification and the clerk says, okay, he's filed an affidavit, he or she has a driver's license, blah, blah. I'm certifying, if somebody doesn't like what the clerk has done, because this clerk should not be an investigator, they should go file a lawsuit. And if somebody gets elected and there's some problem there, I feel like they should file a lawsuit. And I think this should get out of the political process. I think it's terrible. What I was going to ask you, Nate, was, does the section that you're talking about, 102, does it cover all, first of all, is it mandatory?
Yes.
It is. In other words, the state has preempted the area of how you challenge election.
Well, so those are two slightly different questions. So under common law, there is no right to contest an election. So there's no legal remedy absent statute. So the legislature has created a limited manner by which a party has a right to contest an election. So I just pulled it up in sort of guessing what your question might be. So here are the only bases for an election contest. The only bases for an election contest are misconduct, fraud, or corruption on the part of an election official or the canvassing board, sufficient to place the outcome of the election in doubt.
Okay.
Ineligibility of the successful candidate for the either nomination, if it was a primary, or the office in dispute. So that's eligibility to serve in the office rather than qualification as the candidate. Receipt of a number of illegal votes or rejection of a number of legal votes sufficient to change or place in doubt the result of the election. I remember there was one in I think maybe city of Miami, where they had to actually redo an election because a court found that there were a sufficient number of vote by mail ballots that were squirrely, is a legal term, to place in doubt the outcome of that election. And then D, which is proof that an elector, elected official, or canvassing board member was given or offered a bribe for purpose of procuring the successful candidate's election.
So just in the theoretical case that somebody gets qualified by the clerk, and somebody said at that point, says, oh, you said you lived in that district, you live there. So 102 provides.
102 doesn't provide for that, but that is that's a common law right that you have now.
Right.
You can sue for
Is that-
you are not qualified to be a candidate.
I'm familiar with that.
Yeah.
Okay. So 102 doesn't cover that, but if but you can file a lawsuit and say, and I think that certainly another candidate would have standing, and I don't know whether any voter would have standing, do you know?
Only because of having reviewed certain cases, I don't think any court has truly addressed that limited issue, but the statute says any elector, so if you're
Alright.
dealing with a
So let's
post.
assume that for the moment that the court, that there's a procedure by which if somebody said, I live here, somebody else says you don't live there, that somebody can go into court and the court will determine that you probably can get an expedited, hearing and so forth. So I think that that's covered. I'm comfortable with that. Okay, so now somebody gets elected. And somebody says, well, you lived in the district when you qualified, or didn't, I don't know. But right now, you're not a resident of the district, and therefore I want to challenge that. So 102 provides a procedure for that.
Absolutely, it must be filed within 10, and again, to avoid a situation where you have an ouster scenario.
Because I think what happened was very embarrassing, to everybody. It was uncomfortable for the candidates that won, it was uncomfortable for the candidates that lost. It was, so I'm comfortable, subject to sort of Alan confirming everything that, that Nate said, which I'm sure is correct. My partner says very good things about you, and you're very
They're
smart.
all
I
false.
just, and Mark Herring too, so I'm.
So anyway, I think I'm comfortable that those two processes, send it to the courts, get it away from the commission. I know that every charter says they're qualified. I think it's a terrible provision. I think we should take it out, let the courts deal with it up front. Under common law, deal with it at the end, under the statute. And be done with this issue.
Ben should not be here. And we had this discussion in the past charters about doing more to adopt state statute and state governance versus here, because it's too political what they, we just sort of, so we know.
What do you think about that?
Oh, I agree, yeah. If you were to make that as a motion, I'd be happy to second it.
I agree. I think it's like ethics. We have some great
So
state
that's what I'm saying. I think
statutes.
that we should direct the city
Yeah.
attorney to make whatever changes on this section of the charter. To eliminate stuff that puts the city commission in the middle of this. And to just allow, if you want to say it's covered under section 102, say it. If not, it's covered anyway. But you have to streamline this process and take away any of this uncertainty so people know exactly what it is and what they need to do, and we don't ever have to deal with that embarrassment.
And take it out of the political
Take it
process.
out of the-
Yeah.
Yeah, you could put something.
So I make that
I'm happy to
Whatever
talk with
that-
you about it afterwards, if I can provide any assistance on this, but language in your charter that were to say that, challenges to the qualification of a candidate to run must be brought pre-election. And any contest of election must be, made in accordance with.
Whatever
That's-
falls on.
Yeah.
Yeah.
If that's even necessary, because the law speaks for itself. If you look at the handouts, I crossed 3.04 out completely, suggesting that be deleted.
I didn't say that section pretty much, but if you could bring us back to the next meeting, it'll be on the follow-ups. What we need on this issue to take care of this issue, that would be great. Okay. I'm gonna put
You
it-
ought to-
What else go beyond this?
I don't have it, I was not prepared to discuss specific language today. If all I need is what you did, that's fine, just bring it back. Yeah,
Okay.
I make the motion.
Second.
All in favor?
Call the question.
Yes.
All in favor?
Yeah.
Great.
And just because again, I want to be respectful of the thing this time. I know that we have raised the issue of primaries. We've been very clear in what state statute says, which is that according to the special act, we're going to have our elections in November. There is no mechanism for an August primary. I know that we are likely to hear about this, especially as we go out into the public. So the only mechanism that I can think of that would even be able to entertain something like that is asking the commission to request a local bill. And past that, we really can't put anything in the charter that would be consistent with state statute.
Could you explain that a little bit better? A little not better, but a little bit more, what's the problem? You can't have a primary?
It absolutely cannot. The primaries were abolished under the state, under the local act.
For Broward.
For Broward County. There are no.
So
primary
no
elections.
cities have primary elections. So it's just, what do you?
No city that holds a November election.
November elections.
It's solely for the purpose of.
And
November
our
election.
elections are set in November by what?
We did that within the charter, voted on 2019 by the
From
voters.
March. So what happens? So there's an election and nobody,
First past
it's
the
whoever,
post.
so so somebody, you have, this is, I understand, so you have commissioners who are serving that do not have a majority vote. Correct. Right, and that's.
But you have that governor, you have that state legislature.
No, but I'm not criticizing,
Yeah.
I'm just trying to make sure I understand it, so, and there's nothing to do about it.
There is nothing that can be done about it, given the statute. And I would also comment that even for those cities that have March elections, none of them have primaries. It is all first past the post.
Yeah, a lot of cities in Dade have primary elections.
Right, yeah, I mean, for Broward County.
Okay,
Here's the language out of special act, is municipalities that have general elections in November of even numbered calendar years shall not have primaries for such elections.
would we have to have an even number of counties? It could be every. We have to have it an even number of counties.
Well,
If you were to go
piggyback
back
on
to off-cycle elections, which I know that the last charter were changed to go with the every 4 years, when you changed from 3 years, you're again holding your own.
It was,
Private
it
elections.
was a discussion of financial responsibility of how
I
we
understand.
best
So that's the
set.
trade-off, saving money versus having a primary.
And saving money and
Yeah,
and
turnout.
producing actual turnout.
Huge.
And then the other section of this, which doesn't really impact you, but impacted the city, was the organizational meeting of 3.09. Because it's inconsistent with when we had the March elections. And they had the swearing in, and here it delays it till December, and actually the original ordinance, for some reason, they said January. And then when you go back and read through the commission meetings, they realized they were shorting themselves an extra month of the new salary because the commission that got elected in 2018.
So the charter needs to be
Triple.
conformed to know, okay, will you do that, Paul, please?
Yeah.
Well, also look
I
at
have it
310
right.
at the same time, because that piggybacks on 3.09.
3.09.
So, if you look at what I,
Sorry to
And
interrupt.
that was the inconsistency.
Yeah, does anybody
Yeah.
need me for anything else? Because I have a 7 o'clock meeting. I
Good.
gotta make.
Thank you.
Okay, so thank you. My pleasure.
We'll probably need it back.
And again, happy to. You all the time, happy to assist in any way. I can. And thank you. Have a great day, everyone.
Thank you.
so on 3.09, I think the fix is easy because, my suggestion was just to take out the words in December. So we read on the first regular meeting day following each regular election, the existing city commission shall, and leave the rest of the language the way it is. And my explanation for that is section 4 of the special act as amended provides in part that in any general election or races for municipal offices in Broward County, the candidate or candidates, depending upon the number to be elected, receiving the highest number of votes in the election shall be the winners. Such duly elected municipal officers shall take office within 14 days after the general election, with the specific day to be decided by local ordinance. So the first regular meeting following the regular election would be within 14 days.
So could you go through that and come back to us with the draft that includes everything? I know that.
Yeah.
But I
And just
mean,
make sure it's
just make sure like we're
consistent.
taking,
with
it's all
the state.
consistent and so I'll put that as a follow-up, the charter changes on the election. The whole, and maybe we get to that.
And then address 3.10 at the same time.
Yeah, right. Go through that whole election section, please, Paul, and make whatever changes necessary to clean this thing up so we don't have confusion. It's clear. That's right.
I have 3.10 if you want.
I know. I just want you to look at it again and bring it back to us. That's all.
And then
Maybe we
the,
need 3.10 for 3.9. Worded the way that you suggested.
right, it wouldn't,
So what I suggested on 3.10 is changing it to read as. I'll tell you what it says now. On the first Tuesday following the election, a new member elected at other than a quadrennial regular election, the commission shall meet to receive such a new member. So what I proposed is a member elected at other than a quadrennial regular election shall take office following certification of the special election by the Broward County Supervisor of Elections.
Wouldn't it be at the first meeting? I mean,
Yes, some time period.
Well, but then you have the issue of the overseas ballots, wasn't there?
Well, just.
But they don't certify
Yeah,
it.
but they put it in a time period that's gonna work.
Because the certification dates on November elections are different than March, so just get the timeline, he can give it to you. and
Yeah.
make it-
So the reason, so I looked it up, and the reason for it is.
Yeah.
The special act says all municipal elections shall be canvassed by the county canvassing board. With said board certifying the results to each city clerk within 5 days after the election. Now, I don't know how practical that is, though.
Well, that's the
Within
state.
5 days after the election, that's in the special act. And in this, in Florida statute. Regarding overseas ballots, a vote by mail ballot from an overseas voter in any presidential preference primary or general election which is postmarked or dated no later than the date of the election and is received by the supervisor of elections of the county in which the overseas voter is registered no later than 10 days after the date of the election shall be counted as long as the vote by mail ballot is otherwise proper. So that kind of
Just give it
conflicts
a
with
name,
the 5.
Just get,
just give it a
with the
name,
5
because,
days.
because
Yeah.
it was very clear that the November elections have different timelines than March elections. And that's where the
And-
city
and
was
this time
totally
they-
inconsistent.
They didn't
every-
certify the results until after that 10 days. So saying that after it's been certified, first meeting, I mean, that. I
Yeah,
think
that could be. a
And,
conflict.
and the local elections after the certification by the county canvassing board. You did not have to wait for the state canvassing board to accept them as the candidates. It was really like,
Yeah.
one was on a Friday and we were there till 6 o'clock or whatever. And then the state certified like probably Tuesday, Wednesday. Most cities did their swearing in that Friday night, the following Monday.
Not for a lot of it.
No. And then we had to fight again after that, after they were already certified the results. So we can get rid of the ordinances that the city commission inappropriately did in 2000.
right, also, yeah,
19.
Paul, as you go through this, if there's stuff in the code. That is inconsistent with this, let's clean it out, get rid of it.
Good.
Okay,
Progress.
Judy, let's go back to the,
Draft.
we've dealt with the legal opinion, draft charter language regarding the lease.
That's really important. And there's some things, I don't know if we started sharing some of it, but there's one of the points that she raised to me too is about the advertising. And I think in the charter, it said advertising in the Sun Sentinel. And does not take into consideration of today's world. For internet advertising. So David, are you more familiar with Lynn's concern on that one?
So the advertise, I think it just says local. Paper,
Oh,
right? It's not
yeah.
yeah. So. Well, I'm sorry, what was her concern specifically?
That
That it's
it's
just,
restrictive to just advertising in paper versus,
right,
it's almost like what the state did in this past session too, with public notices being on the internet.
so we discussed with the attorney's office in the past when. Their Broward County set up that. That program where you can now advertise on their site. There's a lot of different factors that gone in. We, again. Will probably follow up with. The incoming city attorney once they come in to see if they have an appetite for it, but we. Had discussed it, but we haven't moved forward with using the system that the county has. And I'm not sure many cities have so far.
And the work that Paul did, he's eliminated all that from the chart.
Yeah.
He's eliminated and say that it basically should be taken care of by ordinance, which allows the city to keep up with the internet and whatever's afterwards. So he's eliminated a lot of that language and made it very simple.
Yeah, so if you gut it, for lack of a better word, it becomes moot.
Well, I would suggest that we just start with section 8.01 and go through what Paul's done, because I think he's made a real progress. So just for orientation, there's 3 section 8.01. 8.01, the first one is what the existing charter is, Paul gave us. 8.01, the second 8.01, this is in the agenda package. The second piece is the existing section with line through and underlines. And the third one, which is really easy to read, is clean. So that was very good the way you did. I thought that was really good the way you did that.
Thank you. Which negates this $5,000 question.
Yeah, so basically on 8 on personal property, what he suggested is that personal property belonging to the city shall not be sold except provided by ordinance.
Yep.
I think it's great.
Yeah, I think we'll need some ordinances.
Right, absolutely. Well, I know that's job security. Yeah. So you guys all right with that?
Yeah.
Okay, so I move that that be our first official recommendation.
Second.
Second one.
Actually, that was, Mr. Weiss, that was your suggestion at the last
I
meeting.
think I liked it some. I'm giving you credit. Okay, so the second section is 8.02. The first whole page of it is the existing ordinance, which you don't really need to read. The second section is Paul's suggestion, which is with highlighted, which is underlined and gone through. I do have some questions about
Yeah, and
this.
I can explain some of that.
So you basically eliminated most of it, right? So that what's going to be left is 8.02, the third one down.
There's three.
Just the question out there is just the public notice piece. What's your thinking?
Well, you want me to address it?
Yes.
So the public notice piece, it's only been in the past 3 or 4 years or so. This is one of the statutes I meant to print out and I forgot to. But the public participation statute that went into effect about 3 or 4 years ago, didn't exist previously. So now, before any action is taken by the commission, it has to be open to public comment. So anyone will have the opportunity to address it. Whereas previously, that was not required. There were public hearings that, obviously public hearings were open to the public. But by law, that's only been 3 or 4 years that any measure has to be open to public comment.
By definitions.
That's what I was thinking.
Richard, what's the process in most municipalities?
I think it's all over the board. Some have very specific procedures, some not, and I've spoken to a bunch of city managers about this, just to sort of, and honestly, I went to 2 of them today. And different, not for Lauderdale City, but just, and they're all over the board about this sort of this whole issue, which is on one hand, selling city property is one of the very few things that's irreversible. So when the city commission sells a piece of city property, whether it be a tiny little piece that's left over from an easement or something, or a huge, it's irreversible. So there was some feeling that there should be some process, some public input to sell. Others said, well, there should be, depending upon the size of the property. If it's a small little sliver that's left over because of rezoning, nobody really particularly cares about it. But if it's a larger piece or a special piece, like a park or something, then there should be more of a problem. There was some concern that putting encumbering this too much would prevent the city from doing some things on public-private developments and stuff like that. So I really feel, I don't know how I feel about this, but I know that there is some sort of a balance between having the city be able to do, I was thinking of the current city hall property. I mean, on one hand, I really think there should be a very significant process, maybe even a vote of the public to sell Parkland. That's sort of, I feel like it should be. On the other hand, let's assume that the city wants to sell the city hall property. Or do a public-private development or something like that. You could have a process, you could have public hearings. One manager suggested that there should be a certain time period, that there should be a first reading and then time for people to come out of the woodwork and object to it and stuff like that, more than the normal 2 weeks notice that you would need for an ordinance, something like that. So another one suggested that maybe there should be 3 appraisals, when you're going to sell city property.
Yeah, so-
And so I'm really, I just want, those are sort of thoughts, and I'm not expressing an opinion at all about it, but I think it's like a sort of I'm thinking about sort of like a sliding scale, depending upon whether it's a park, which I think deserves a lot of protection, or down to like a little sliver of property that's left over from something that maybe gets less protection.
And Harrison, you had at the county, and it's really after the whole Spurlow issue about the appraisal process.
Yeah, I believe we have that requirement for 3 appraisals before any sale of major public property. And, you know, I think that the rewritten section 802 does a good job of also recognizing that there are countless transactions between governmental bodies for easements of sorts that are de minimis in nature, and, you know, they may come up for a ministerial vote, but I can't think of all of the quasi judicial consent hearings that I've seen at the county that basically deal with 2 feet of utility easement that I've ever seen anybody come to speak on it. The faster those kinds of transactions can happen, because they really are government to government almost all times. And if it's not a governmental entity, something like FPL, which is the public, we know it there.
And the city just had that with the county over by the
Exactly.
Women's Club with the library and parking.
Right, where we're talking about again, square feet, not square acres.
Measure?
Yeah.
So time does fly. This is from 2013. It was enacted. And so part of the reason that I was suggesting to simplify it was because there is this requirement in the law. And that is that members of the public shall be given a reasonable opportunity to be heard on a proposition before a board or commission. I can read the rest of it if you want, but it explains, you know, the timing, that sort of thing. So I was thinking that since that is a requirement which was not in place before 2013, that maybe it's on. And I guess, I mean, that's all,
I
that's up
think
to
it
you, of
depends
course.
on the property. That is not enough for me for selling the city. Absolutely. I mean, I really don't think that's enough. I think that one thought I had was maybe we should see what we're talking about. I was wondering whether we could get a list of the city property.
Anthony,
You know, get a list of the city property, and maybe they'll sort of fall into categories, and there's some that are. We want to give the highest level of protection. Some we want there to be some process, like for the little ones, maybe what Paul is suggesting is right, like a little sliver here or there as well. But I thought one thought I was that we saw what we were dealing with. So we weren't like talking in a vacuum, because we are dealing with a finite, maybe pages and pages of little slivers. But once you get beyond significant acreage, there's not going to be much, right?
Yeah, no, there really won't be, and I would offer another situation we find ourselves in a lot. We have like leftover pieces of parcels that aren't even usable to be developed. And we run into the situation where the neighbors may want to avail themselves of it, but we have to go through this entire process, and then
That's the other
No,
thing,
it's-
those
yeah,
little
it's just-
pieces, maybe nobody cared, you know.
But we have a map put together. It's just not drilled down to, I think, the level that you're asking me, so
I
I'll
would
ask
really,
them to
I'd like
kind
to
of.
see like a map is not as helpful to me as a list.
Risk management may have it
With the,
for insurance.
the list
Okay.
with the acreage.
And might I just add a friendly amendment to that? So the term of art that I see all the time is suitable for development. So a parcel that is not suitable for development usually is that de minimis amount of size. I don't know exactly where that threshold is, but if that list is limited to parcels suitable for development, I think we're looking at the land that actually is of interest to the charter.
Richard, for the record, are you talking about 802 as well as 804?
I'm talking in general about
Okay.
everything, because I think that even a city park, I think there should be a bigger process to give it to let's say, to the county.
Absolutely, especially if the voters voted for it in a special bond to create the park.
I was sort of thinking more generic, just all the property and maybe some sort of sliding scale on all the property, not saying if we're giving it to the public, maybe there's a separate section if we're giving it to another governmental entity, but people may feel very strongly about, we don't want this to become a county park. It's our local park. This is where our kids play. We don't want the county coming over and putting blah, blah on it, and, I didn't like the language at the end, Paul, where you say with any private purpose being incidental, because based upon the history here, depending upon who's giving the opinions, somebody could ride a truck through that.
Well, that's from case law, that's from the Poe opinion from Tampa Stadium, that the public purpose issue in Poe, and it was divided between, so there has to be a paramount purpose. In that case, it was a bond issue, but there has to be a paramount public purpose, but there can be, and we can eliminate it, of course, but there can be an incidental private purpose at the same time. That would be legal, but it has to be incidental if there's some kind of private benefit. But also, so that was from the Poe case,
Those words, purpose, public purpose,
okay, public purpose, and let me explain
that
that.
is extremely important into
So-
this discussion.
the
To me,
pub-
that is one of the key words in this
The
discussion.
public purpose language that I added came from other case law. And it involved the city of Gainesville, and it was actually a tax. These public purpose cases are related, or you more often see them in tax exemption cases. So what type of property, what type of use, what kind of purpose is so public that is tax exempt? So that's where I got from that Gainesville case. And then there was, in that case, there was a discussion under the 1886 Constitution and then 1968 Constitution, and they kind of settled here. An activity that is essential to the health, morals, protection, or welfare of the city. And of course, I added as determined by the city commission. Or for use predominantly for educational, literary, scientific, or charitable purposes. Part of this is actually out of the Constitution. There was another word in there that was religious. I didn't include religious, but because I couldn't imagine that would be in the mix. So I didn't include religious.
Yeah, and Anthony, when he brings religious, it makes me think, do we have a lot of property that is tied up because it's designated church property that really isn't being utilized and ends up being like
The city
vacant?
owns?
But
The city owns?
that, when religious property, are there a lot of religious
I mean,
sites
there are.
properties that we gain no tax?
The city owns, or you're done a different.
Just,
I'm just talking religious.
You're talking about
no,
tax exemption.
yeah, there are. In 1997, we did a mass rezoning to try and designate all the houses of worship with a specified zoning district. These community facilities, house of worship or house of worship school or whatever. We didn't catch them all, but there are a lot, and I could probably easily pull that if you wanted to see it.
Separate issue. It's just something.
Yeah, that's privately owned property already, that's the city.
Going back to what Paul was saying, I don't really know whether the purpose of the sale, if we have the protections in place, do we need to be dealing with the purpose of the sale?
And don't forget,
I think we need that public purpose, and that's what was discussed.
Something has to be approved by the voters.
Yes,
But don't forget, in this case, we're talking about to sell to public.
I know, but
bodies.
I'm
Yeah.
talking more broadly.
Yeah.
In other words, if a sale of property has to be approved by the voters. If they approve it, they approve it now. Do you still,
if that's the contingency, if it has to be approved by the voters.
it has to, okay, so if it has to be, maybe in that, if you're thinking about the sliding scale. That if it goes to the voters, if voters approve it, that's. If the city commission is approved, and one of the other thoughts I had was, maybe it requires an extraordinary vote of the city commission. So maybe it requires 4 votes of the city, from the city commission to if it's not getting approved by the voters, I said, how else could we provide city commission the ability to do something, but not go to the voters? And I was thinking maybe we had 4 votes in order to sell like city hall property or something, like a big piece of property. So, I have to think about where we have, which categories we need the words public purpose. Like if we're going to talk about what you were talking about, which is, you know, just for getting rid of it, then maybe it doesn't need to be for a public purpose. If it's, you know, I don't know.
But that gets back to your sliding scale. I think we have to define, you know, with some kind of clarity what property falls under which particular
The other
designation.
thing that we've done in charters is that under the category A, we've listed them in the charter. This park, that park, this park, that park, these parks, but this land cannot be sold unless it's approved by the voters, period. And the Dade County Charter's got pages of them. And the Weston Charter has pages of just listed parks. Judy Stern Park, you can't sell it until, you know. And that's another way to, you know.
Well, I believe the city is going through right now and looking at the zoning for
We-
parcels that have historically been parks, but haven't been zone parks. And once they complete that process, then I think that would fit in your category.
Because if we're putting them in the charter, we don't really care what they're zoned. Because if it's, you know, if it's Chris Furtick Park, then we don't care if it's zoned industrial. It's still, it can't be.
But I'm saying that's the identification though in right now. If
Yeah.
They're trying to assemble, as I understand it,
We are.
you know, what is a park? And then if it is a park, you know,
Yeah.
The
incidentally,
reason for that is going along the lines of what you're talking about. It takes a supermajority for the disposition of parks, but it's zoned and used as parks. So finding those, and identifying them and rezoning them is.
The thing that I'd like to avoid is having this start to be a debate over parks or being able to rezone something, so it's not a park anymore and being able to sell it. I'd like to really protect these parks
Yeah,
from
and
it.
just so you're aware, to rezone it would take a supermajority as well.
I know, but still, I don't want to, you know, if these are parks, I want to save them.
Understood.
I don't,
yeah, green space, you gotta preserve it.
right?
Well, it's like the open space theory that we did in Davie years ago.
And I allow me to distinguish 8.02 from 8.04 because the public purpose really is more a matter for 8.02 when you're selling to a public body and you may not get the best price and you want it to be used for a public purpose because you're selling it, you're conveying it to a public body. 8.04 is sale of real property to anyone. And so if the city doesn't need property and wants to sell it, it wants to get the best price. So I don't know that public purpose really comes into 8.04. And what I did here was I made an exception, so except as provided in section 8.21, which is a section of unanimous vote of the entire city commission for land zoned park. So except as provided in 8.21, the city is authorizing the power to sell any, and I clarified this a little because before it said public lands and improvements thereon. I just said real property owned by the city of Fort Lauderdale to any private party as provided, and again, I think yours suggested, as provided by ordinance. And I added and consistent with applicable law. The reason I added consistent with applicable law is because property acquired by eminent domain, there is a restriction on alienation within the first 10 years. The previous owner has a right of first refusal and that sort of thing. So that's why I added consistent with applicable law, because that could come into play there. And so 8.04 also, I just made it simple. If you look at page 4 of what I proposed, just very simple. Again, and you may not agree with this. Again, I go back to the public participation, which may not be,
I don't think it's.
I get that. But that was my thought at the time. So I simplified it. I thought that's what you wanted.
I did.
Yeah.
I think you took out a lot of stuff that I don't think is important. Did you have any thoughts about CRA property? Because they frequently acquire, you have a CRA, right?
Yes, I do.
You acquire, the CRA acquires property. And then puts it together sort of in parcels with a specific purpose of selling it to private developers. And I don't know whether we need to, I was thinking about CRA property, and wondering whether we need to deal with CRA property separately, where I think it might be easy, make it easier for the CRA to get rid of property, because that's what they're doing. They buy, individual homes, whatever, they put it together in a larger parcel for the specific purpose of then selling it to a developer so that they can make something, an improvement in the CRA. So
Isn't that more addressed by statute?
I just had the thought.
I think it is, and also,
And
also
Ethnic
sunsets
that too with the
Sunsets
CRA.
and like.
I know, but
Yeah,
CRA property,
Twenty twenty-five.
2025.
yeah,
yeah, several years, sunset for
the
years.
CRA is city property. So if we start to put some limitations on it, we don't want to limit the CRA for as long as.
And there's a discussion of extending the CRA or finding some other method.
We have to assume that it's gonna be.
Goals.
I think it should be cool, yeah.
I don't really know what to do with CRA property, but it was just another thought.
And the city's been inconsistent too, and how they've treated CRAs as to who the private person is versus the other private person. And we've seen that kind of discriminatory practice within the city.
I also, on the next section of the leases, I almost thought that it should be this is fooling around with 50-year lease in place. I almost feel like any disposition of property, maybe, could be the same. So if it's a park, gotta go to the voters, even to lease it for one day, not one day, but more than a term, but and then the same thing, maybe a sliding scale and that, so there's not a differentiation between, because if you lease property for 50 years, I mean, it's just like, 99 years is just hell, but 50 years is a very long time.
Well, and when they gave the licensing for 50 years for $1 a year, and the city only gets to use the property 4 days out of the year.
Yeah.
So
I
they
know.
gave away acres of land for 50 years for $1 a year. And the
So-
city only gets it for 4 days.
So the thought that I had was maybe we put all this stuff together and that there maybe should be not much of a distinction between. Leasing city property.
And did we include the language so we can no longer do licensing agreements so that it's a different process?
Yeah, because Paul did a good, he listed a whole
Addressed
bunch of
it was-
different
yeah,
things,
this was
but I was
outrageous,
thinking
but
of
the
sort of
city
mushing it all
gets
together
it.
instead of just sale of city property. Sale, lease, conveyance, blah, 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 of parkland, no matter what, has to be approved by the voters. Sale of another, Group.
That's there already, that's in
I understand,
in the section that was done, 2004. It includes leases.
so,
Did anyone address in section 8.04, section G about the real estate commission to any registered real estate
I
broker?
think it should be just brought back, I think this is. I mean,
Because the city has this deal where it's 4%, I don't know if it's more now.
I suggested it just, I might review of the draft, I think it just should be crossed out, whatever the city negotiates with the realtor, it's like. Sort of,
I did that, didn't I?
no, you left it.
You're right, I left it. You're right. Oh, the reason I left it was because I looked at the purchasing code to see, and maybe that's the fix, to add something to the procurement ordinance. Because this was not specifically in there as some kind of exemption. And that's why I thought it needed to still be addressed, but the fix may be the procurement.
After we do this, you guys are gonna have to go through the code and. Because otherwise you'll end up in the same mess that you're in now with conflicting code and charter provisions.
That may be the fix, because that's where I went to it first. to see if
When
it was
we
in
were leasing property, city property in the city, therefore we are really the owner's rep and developing and managing the property. They tried to force us to pay a commission,
What's your thoughts about,
which didn't make any sense.
about not really differentiating between. Sale and lease? Do you think that we should have something separate on those provisions, or you think that we should just protect the property? I don't know. What's your thoughts?
I do think that these are different. Again, I look at the fixed base operations with a visibility here. We want on certain properties, and again, I'm just gonna pick on the airport this for here. we want private companies to build hangars and operate them as if they basically own the land, but they don't.
Right.
And so again, treating a lease, and I don't know, the standard term for those leases is 10, 20, 30 years. There is a distinction there that I think is worth carving out. I understand the issue with licensing versus leasing. I'd rather keep consistent licensing and leasing requirements, but I don't believe that those are the same as the sale. Personally.
So let's say that they lease something for 50 years.
That, again, if they're gonna make private improvements to that land, and I'll just pick on the hangars. They have basically the right to operate inside of those spaces. And if you're gonna ask a company to put millions of dollars into doing that.
Right.
They need that consistent ability, and also having those long terms. I know it seems like it's counterintuitive to public purpose, but you're not gonna be able to finance something without the guarantee that you have.
I agree with you. I think that you have to
And
be
we
able
do
to.
have a separate section that we probably should address at some point in here, specifically on FXE.
Right,
Because
and-
FXE is so unique. And it's
You need to
worth,
deal with
it's
something
worth
more
a section we should absolutely be looking, because it is a different expenditure and purpose.
So if you have a category parks, let's say we're gonna give them, whether you lease to anything to a park, we're gonna give them. So this is next kit, we have the category on the bottom, which are these tiny little things that we don't care much about.
Right, not so.
So we're dealing with the section in the middle, city hall property, right? Sure. Okay, so do you think that, let's say we say that in order to sell city hall property, you need 4 of those. So that's that middle category, I'm just making it up. Do you think that to lease city hall property for 50 years should be any different? than
Well, right now, the leasing is unanimous, right?
that? Only on part. Okay, I don't know. I think.
Well,
only-
That's why they did a licensing agreement on Lockhart, because otherwise a lease would require unanimous vote.
Well, let's assume we cover the language, which is lease, license, blah, 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 blah. Should a
Well,
lease
one-stop
license
shop's
or blah,
another
blah, blah
example
be
where
any
they gave a
different?
license instead of lease.
Sorry, I addressed this a little bit in 809.
Yes, you did, but I'm trying to.
I also-
come up with
Yeah,
a
I
broader
see what you're
frame,
saying,
should it be dealing any different?
but. You know, the lease, we do have the 50-year restriction that we talked about, so that is a carve out on leases.
I also tried to clarify that a little bit by saying that no such agreement, lease license, facility use agreement, whatever, no such agreement shall be renewed or extended earlier than 1 year prior to its expiration. And that's just an idea I had. You can do whatever you want, but this way it won't even be up for renewal until until the 49th year.
But that's, again, maybe letting the camel's nose into the tent. With providing an exception, that people would say, okay, well, we're gonna do it for 50 years, but we not.
But you couldn't do it, you couldn't do the second 50 years at the beginning.
How does it impact the finance for them for the investment?
Well, at least 50-year lease, I'm not saying we shouldn't approve a 50-year lease, I'm just talking.
I'm just.
Again, I don't know where I am on this, I'm just talking, please. I mean, if you have a 50-year lease that's approved by the super majority of the city commission, it's the same as a 50-year lease that's approved by a majority of the commission, doesn't count.
When you say super majority, you're talking about 4 or unanimous? 4.
Because currently it's unanimous.
I don't think one person should have veto power to stop something, but I think that for, you know, if you're making it unanimous, any one commissioner gets some idea that I don't think. So I sort of ended up with my super majority being.
So you're suggesting that we make it a super majority for 50-year leases, which I think has a lot of sense.
I'm again, I don't want you to think that I'm said anything, and I don't.
No, but I'm just
talking-
following your
just
thought
talking
by
about it.
putting leases in that category.
Yeah.
But with the proviso that 50 years is the maximum.
And
Meaning no back to back.
Yeah, no back to back
That all board stipulation.
absolutely.
What is what I put in there about no renewal earlier than 1 year enough, or you don't want even that possibility? See, I wanted to make it clear. I tried to make it clear that way, so that there would not be the back to back.
Or you could still do back to back, you just have to wait till the 49th year to do it.
Right, but you can't do it at the beginning,
Right.
Which
But
is what I
Chris
thought
is
you
saying
wanted.
Here's the,
no back to back.
which is what I thought you wanted.
Okay, here's the question, if the moment we're talking about, you can't sell city property without 4 votes. We're talking about this middle category. Why shouldn't the city commission be able to lease, if they can sell property with 4 votes? Why shouldn't the city commission be able to lease property for 99 years with 4 votes? Intellectually, if they can sell it with 4 votes, why shouldn't they be able to lease it with 4 votes for whatever they
But
want?
99 years is essentially a sale. I know what you're saying, but I think that is an abuse of leasing.
But then they can sell it.
Circumstances
Let them
change.
sell it.
I see what you're saying.
Yeah.
I see what you're saying. It's the lease, yeah, I understand. So there's some distinction between.
Yeah, the city would then get a fair price for that property at that time,
Yeah.
rather
That's what
than
it is.
having these, you know.
Right, it's basically becomes a sale without a sale.
Exactly.
Plus, the market could be different in 50 years, the economy, all the circumstances.
Again. Going back to what we were talking about earlier at the county, with the appraisals on the property. To identify the value, because they're giving it away. $1 a year for 50 years. For property that's valuable property.
Do you think for committed, if there's a lease for 50 years, I'm now
And they-
understanding the distinction, let's assume. For a sale. Maybe there should be some sort of appraisals or something like that, and 4 votes. But does the 4 votes provide enough protection so they're not leasing property for expensive property for $1 a year? Does it provide enough protection, or do we need appraisals and estimates of a lease like that?
Well, I was in favor of appraisals last week, last time we met, and, you know, depending upon, again, you know. The category that it.
We're in category 2, like.
Yeah.
To buy city property, Alan, Anthony, when we bought park property, I think it requires what, 2, 3 appraisals to buy.
Yeah, but you gave
city
away license, you
buy.
licensed away city property for
I'm talking about
$1 a
buying
year for
parks.
50 years and tied up. I mean, you gave away property. Acres of property for $1 a year, which is outrageous. And did it just by licensing so that you didn't need unanimous vote. So we
Can I go
have
back to
all
my
these
question?
issues
All right.
for the land.
So if you could answer that.
I'm not
question.
as familiar with that process. I think you're right.
I think
I
it's 2
think it's
appraisals.
at least
to
2.
buy, at least, so I think you do the same in selling.
To sell.
If we're buying and have that due diligence, same for selling or leasing, to
Mhm.
your point.
Yep.
Or licensing, whatever nomenclature we're using.
What we're basically saying is you can use whatever nomenclature you want.
Exactly.
Same
Same
standard.
thing, same standard.
50-year
have to
lease.
do
should have
$2
a majority.
Yep.
Maybe we should just say they can't lease property. I mean, counties can't lease property for 25 years, I think. It's a statutory limitation.
Mhm.
on it.
And there was also something at the county about on the eminent domain.
That's another barrel of fish. Yeah, when you're doing eminent domain, you have to get the appraisals because effectively you are seizing property, but then compensating the owner under duress. I wouldn't want to use that as the precedent here. I feel like that's a kind of an ugly mechanism. Where we are talking about the fact that there will be proposals for city-owned property that are forward-thinking, that are gonna make improvements. That are well beyond what the, value of the undeveloped land will be.
Yeah.
And also, again, if it is a lease where at the end of, 50 years seems like a long time, but 50 years will pass. If the city still owns the property with the improvements made by the lessee.
What we saw with
But-
the HMR is they kept renewing the lease midterm, and that is another mission creep that we have to
which Paul kind of addresses with
Yeah.
this, which I like. And then the other
In the-
question
in the
is,
licensing agreement that they were doing, the property reverted back to the original form. Prior to the, I mean, the quality of what gets put on 50 years later is not going to be of any value.
Sorry, I'm less familiar with this. So if by license, we are building pickleball courts, I believe that was one of the issues. The pickleball courts are gonna be destroyed before the land goes back to the city.
Well, we're talking about the stadium.
No, it would revert back to the city, whatever the structures are. But talking about the financing aspect, 50 years is a long time, and banks will finance projects, for a lot shorter term,
Terms.
True. And I will just say that when I was on the Hollywood City Charter Review, one of the issues there was the 99-year lease term, and we basically were told by Mr. Tabachnik, if I'm pronouncing that correctly, that Margaritaville would not have been financed if it hadn't been for the 99-year lease mechanism. We actively debated either bringing it down to 50 or using, again, another threshold there. We ultimately, and again, that was the body of folks with pretty strong opinions on this. We wound up keeping the 99-year term into the charter. We did think that ultimately, in that particular case, we got a good deal. That was Hollywood. This is a completely different situation. I understand and respect. I'm just saying that the last time that I confronted this in the city charter, I very strongly came in with the opinion that 99 years was way too long and walked out saying, you know what, we need to keep that language.
The city of Miami can't lease any property at all without a vote. So you could say 4 votes of the city commission to lease property up to 50 years. Anything longer than that needs to be approved by the voters.
And the Inter Miami facility in Miami, city of Miami,
Right.
how are they doing that money? Outside, they're paying tremendous
That went to the
dollars to
voters.
the city of
I
Miami.
went to the voters
Went to
twice.
the voters.
and then here's a question with the 50-year cap is, what is the required dwell period?
The what?
Before, I'm gonna call it dwell, and the military would call it dwell, like, what's the period between the termination of the first 50-year lease and someone's attempt to re-engage another 50-year, is one day sufficient, or what's the, see, you'd have to define that, is that fair?
That's what I think Paul was trying to do with his,
Renewal.
Here.
maybe renewed or extended, but that doesn't
That doesn't
open it
cover it.
open up for other people to bid on it and say, well, we can do better.
But it may be such a good deal, even 50 years from now, that you want to consider.
Correct.
That the city at the time may want to.
You
may
don't
want to
think, you
continue.
don't think a 4-vote commission? Do you think, I mean, I feel like 4 votes on this, you can get 4 votes on the city commission to do something. It's gotta be,
Well, it depends on the property. If you're talking about parks,
no, I'm not talking.
like, that's what I'm saying. You have to
Forget,
classify them.
I'm talking about our category 2, which is what we're talking about, whether, there should be some ability to go over 50 years, maybe with the vote of the people.
Yeah.
Or, like even the renewal of the lease, they lease it for 50 years, requiring 4 votes of the city commission. That's a lot. If they want to renew it for another 50 years, it's 4 votes to the city commission. I don't know whether that's enough or not.
But using this language, it could exclude other people to bid on that property and say, well, I may have a right to negotiate the renewal versus saying, no, we're gonna throw this out into the public. You've had it for 50 years. Let's see what other people may want to do under this.
So that goes back to day 1, which is if you're going to lease city property, should it go out to the public and say the city of Fort Lauderdale is interested in leasing the category 2 property. And anybody who wants to come in, you have to receive proposals. I mean, that's another way to go.
So is there any other property, Anthony, outside of the separate sections specifically with BPMR that gets beyond the 50 years?
I don't believe so.
So
I
the
think that's
BPMR is the only one.
one that's got its own.
Everything else falls within the 50 years.
Like, that's my understanding.
And can I answer a question just related to something you just said, and this might be addressed in the procurement code? Is there a requirement after the city receives an unsolicited proposal that there must be some competitive process. Because again, I think that
That's
that would
under state
cover.
Statute, yeah.
Yeah,
Right.
state statute.
Yeah, because I know that we, as the county, when we were interested in possibly doing a joint government center, we started with an unsolicited proposal. And that kicked off a long process that sadly didn't come to fruition. On the record, we'd really like to see that come back. But that's.
Well, you know, the state law on unsolicited proposals is really complicated.
Mhm.
And it depends upon who the solicitation comes from. And then you have to do certain things, and if it's part of a financing package, it's one thing. I don't remember enough about it, but I know that it's really complicated.
There are a lot of requirements that have to be met. For an unsolicited proposal to even be considered.
You have to advertise.
There's a laundry list. When it comes in, the determination is made whether the responsible government entity, I think it's called, wants to go forward with it. If so, the statute requires an advertisement in the newspaper and in the
It's a very.
Florida Administrative Register, I forgot what it's called, something like
Florida
that.
administrative, yeah. Florida.
Something like that. And so the notice has to say that the city has received an unsolicited proposal for XYZ project and will receive proposals for the same project within a certain number of days.
I think the city was doing, Anthony, was it 30 days or?
Well,
That could vary.
the statute, I think, lets you go down to 20.
I think 21
And I
to,
think that, yeah, like 100 and something.
I have it.
180 maybe. I'm not sure the upper threshold, but one of the conversations that I've heard talking about this is that depending on what the unsolicited proposal was, 20 days may not be enough for somebody to put a substantial package together to address that same issue. So if it's something you're considering, it might be something you want to put in there.
255 proposals.
And the other question in the consideration is the actual business plan. And that's been the drawback because that's been the big issue here. Is now we see business plan attached to make it financially, to show that's financially, and they were still voting on it as an unsolicited and then doing the licensing.
Yeah, a lot of, I mean, people elect city commissioners that are not gonna look at things properly. I mean, that's the democracy, you know, they're gonna elect who they're elected of the people. I mean, we can't write that city commissioners are gonna be responsible. We can't write that we're gonna do the right thing. We can't write it that way. I mean, you know, they can do whatever they want to do, and that's democracy. If people elect people that are not being careful and stuff like, I mean, that's who they elected. I'm big believer in democracy.
Yeah, but the purpose of the charter though is to draw some type of
Guideline.
boundaries,
Right,
around
exactly.
what
That's
they-
what I was talking, that's when I talked about irrevocable decisions. Like if they decide to give huge wage increases, it can be corrected. If they decide to spend some money, you know, but this they can't correct. That we can correct.
That's why this topic
Is so important.
By the way, it's at least 21 days, but no more than 120 days. After the initial date of publication. That's
Yeah,
when we did.
Judy, to deal with what you're saying though, like on a lease. If the city commission, somebody comes to the city commission and I just dealt with this in an unnamed city, they came and it was not a good deal for the city. But they, you know, they hired a bunch of lobbyists and they sugarcoated it and they made it sound real good. And in the end, the city commission didn't go for it. But that was because, you know, the staff made a recommendation, they hired an outside person that said, this is not a good deal for the city. And the city commission, you know, to the very voted against this very unhappy group of lobbyists. But if they had voted, they had one more lobbyist or whatever, you can't, if the city commission gonna make a
Right,
bad deal.
and the, what they did here.
By
was
the way, I
find the
say that as a
loophole.
lobbyist. Not being
What they
critical of
did
lobbyists.
here was they found the loophole that the word licensing agreement was not contained within the lease.
Right.
So that's
We're-
how they
we're done with
circumvented
that.
the charter. They
We're gonna
circumvented
close
the
that.
charter by giving out licensing agreements that were bad deals for the city.
Well, we're gonna try to protect this.
So if we put the licensing in with the leases, then it cures that.
And just as a point of information, because again, very curious about this idea of unsolicited proposals. If 120 days is the maximum, is that basically equivalent of the amount of time that the city allows for an RFP to be submitted? Because I'm trying to get a sense of what in your procurement process, 120 days is. Is that take a really long time? Or is that the average for any kind of major proposal that has to be considered outside of the basis price?
I don't know that we have a time period. Do you know, Anthony?
No, there are in the procurement rules. I just don't know them well
I mean,
enough. There's a minimum, but I just don't know what the,
I don't think it's the ordinance. There may be something in the procurement manual,
yeah, I believe there is.
which I could look up if you want.
I also think it depends upon the complexity of the project, you know, like if you're talking about, you know, an RFP to lease, you know, some thing and do a public-private development, blah, 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 you need a lot of time to put together a team and stuff like that. If it's something simple, not so much.
So again, just, I'm sorry, to finish the thought. The absolute. Just amazing work that went into the proposals that were considered for the joint government center. Again, he sadly didn't go anywhere. They were put together, I think, at a level that really showed that when. Property that is publicly owned. Is up for bid. This area has the kind of demand that world-class teams of developers are willing to come to us and say, this is the work that we can do. And I think that provided that there is a trigger for a competitive process, whether it's a license, whether it's a lease, again, sale, I think does have to be treated differently because it is final and irreversible. There is the possibility that provided that we're not putting unnecessary barriers to entry, something great can come in the door. I think again, the goal of the charter should be, how do we make that door as open as possible for the best things that can be given to the electeds? And what is something that is strong enough that can carry a super majority of and majority plus one vote? Whether that's for.
So do you think there should be a process for anything that we're discussing? Like, let's say they want to sell a city park. And we know it's going on the ballot, just for the purpose of discussion. Do you think there should be a process before it can go to ballot? Should be able to.
I think that if in that case, hypothetically, there should at least be 3 appraisals on property. And if, again, there is any business plan that has been submitted, that needs to be available by the public.
But does there need to be a master? I feel like there needs to be a competitive process.
Oh, yeah,
For sale of city, for sale of city.
absolutely.
In any case.
Provided that it meets that threshold of suitable for value. Again,
So category 1 and 2. Part and the whatever. So you feel like there should be a competitive process for any sale of city properties, let's say categories 1 or 2.
Answer your question.
Sure.
The RFP document is from the procurement. The RFP document is released to vendor supposed to do back probably between 3 to 5 weeks. Or at least that's it.
3 to 5 weeks is the standard time for
RFPs.
That is a short window.
But it depends on the project, depends on. the RFP.
So again, 120 days actually does seem pretty adequate in comparison.
So that's been consistent with some of the projects. Just make this kind of, when they finally up to bid, yeah.
Well, it says normally. 2 to 3 to 5 weeks, so it's not a set start.
Let me check with purchase. and see what they-
Sorry,
Maybe,
I can't hear you, but Lorraine.
Just saying, is that normal?
3 to 5 weeks? Yeah, typically, I mean, when I've talked to procurement manager, you know, since you can get stuff done in about 4 weeks, 3 days. We're trying to move quickly. So yeah, that sounds right. That's what I've been told pretty regularly.
They also have a unique situation here, but they don't do tons of silence on the commission during procurement. They don't do they
We have to
don't
speak louder.
keep minutes.
Our audience can.
They don't keep minutes. You can't go to a selection committee that's appointed by the manager. You're different than the county where you have the administrator appoint the selection committee. But there's not a audio or video tape of that meeting. Have they changed that?
No, I don't believe so. I mean, what you end up with at the end of the process, at the end of that portion of the process is the rankings and even no changes to staff is made. There's no. But
Yes. So this is-
Right, so just in an effort to keep, so what's our kind of action plan here with 8.02? We have guidance for all or?
Well, I think what Richard is saying is maybe we need to find some of this categorization, how we're going to break down category 1.
Okay. So. Differentiate.
I was wondering whether there's consensus that however we define category one, I'm gonna call it first. That's one of the voters. Consensus.
Sure.
Yes. Yeah. Okay. For parks, everyone, for parks. Okay. So that's good. Question, second question is, do we have some consensus that for any of these things, there needs to be some competitive process? Absolutely.
Yes.
So those are two, great. Okay. Then we've asked, if you could give us a list of properties.
yeah, I sent an email
So we can see to know what we're talking about. May not, it may be very obvious what we're talking about. And then maybe there's some consensus on the third category, which is these de minimis non-development pieces. I think there should be something, but some here, not valuable, but
The cases where it tends to be a little bit more contentious is, let's say, we're releasing an easement that's on a canal that's adjacent to the property, but not necessarily adjacent to your neighbor's property, right? Your water. You should have first right of refusal to get behind that. And
on those little pieces, I'm okay with allowing it to be set by ordinance, or they let them pass an ordinance that deals with.
But I think if we don't bring some of these ideas forward in communication, then they'll never even think about having an ordinance to address them.
There needs to be a report from our group that says these are the charter recommendations. And then there needs to be some commentary based on all these discussions written about these other things. We think there should be an ordinance for dealing with these two.
I think what we should do is finish going through section by section and then have a current workshop.
Following up what Richard's saying, we have to associate them with that category 2, sale of public land.
I didn't want to push it, but
Yeah,
I'm still thinking.
that's what I'm hearing.
So we have consensus on category 2, however we define it.
Yep.
Right. Right.
Excuse me, Chair, can you repeat that?
Category 2 requires 4 votes.
Oh.
And then also, I guess. But we also decided last time, also, like you said, however, are we okay with combine, where do we end up on whether we should combine leasing with these categories? So your lease, part requires voter. If you're going to lease category 2 property, it requires 4 votes. Do we reach consensus on that? Or we need to think
I'm
about
in
it?
favor of it, if that's what you're asking. But I
You're
think
not-
at least we
Area.
have to have a carve out for
Yeah.
that 50 years.
So I think we're gonna have a separate section on the lease. I think you have to have the carve out, but I don't.
I can foresee licensing operations as bars, not necessarily licensed to the level of sale or park.
But you're talking about licensing as far as a concessionaire.
Right,
situation,
and maybe
not
this is my
licensing waste land.
misunderstanding. Right, and I also don't want to overwrite a regulation that is, again, well-intentioned and just creates a blockage to any kind of development outside into inside a park because it's a problem. in which case then you only have construction being done there by Parks and Recs people for foreseeable future, not necessarily I think in the best interest of the public. Again, I can foresee, say, Holiday Park, Victoria Park. I don't know exactly who is the operator of the separate tennis courts, but if that was under a license through a private vendor, I still think that that's a good public purpose. If it is done by the city, again, I'm picking on this one as
They
actually,
have a concessionaire, I think that operates that. I've never seen that
Think so.
on the agenda.
and so again, I just don't want to, in my mind, licensing is closer to a concessionaire agreement within some of the public lands, provided that the license does not convey the land.
Yeah, see, and that's what they've been doing, is conveying the land over to the developer through a license agreement versus.
Maybe
So
that's
you
the
want to
differentiation.
separate
Right.
and
Conveying land
deviate concessionaire versus licensing.
And that's just where, again, I just want to make sure that we are incredibly careful as to not over define, under define what we are referring to as licensing, which again, clearly is a problem. I can very easily see, in the same way that sometimes you open up a loophole and try to go through, I worry about erecting a wall that will stop any tries.
Chris, how do you feel about that, conveying land? Majority going to voters.
Well, that's the definition of what's conveying land. I hear that there is some concern, but I think we have to figure out how do we separate a concessionaire from someone who's just come in and build a nightclub on a one-stop shop and.
Or for the stadium on the acres,
But I think.
it's just promises
Well,
and not paying
the
building.
Dade
permits.
County ordinance allows certain concessions and parks, which is what we're talking about. And
It's very,
I'm not sure about the Broward County, but I know Dade County allows certain concessions that are open to the public. You know, like if somebody wants to have a little snack stand in a park or something like that. City commission wants to do that, that's not conveying any interest in that, it's just getting.
yeah, and most people, I think when we think licensing, we think concessionaire, we're not thinking of using it interchangeable as a lease of the land for the 50 years to circumvent the charter's requirements of the unanimous vote.
Well, good, so I think we've got consensus there. Yeah, good.
I'm willing
Okay.
over
Great. Paul, you good?
I have Dade County. So my question is, how we are going to, we were making some progress here, how do we? I guess, Paul, it's up to you, I mean, Paul, we've got to take what we're doing, we've got to start putting this into charter language that we can approve, I'm sorry. Yeah.
So, do I hear what Dade County says about it?
Let me finish my thought. What I'm saying is that in order to not keep going back on the same issues, we need to come up with charter language, you know, we need to, okay, let's come up with some charter language. Discuss the charter language. If we're happy with it, that's great. If not, let's go back and revise it, but we need to move off these, if you need to be done.
Need some structure. to
We need some structure, and the only way I know to do it is for Paul to bring back draft charter provisions like he did last time. We've all pulled it apart, but he did do what we asked him to do. And that sort of mirrors what we're doing, and we bring it back and we look at the language and say, okay, that's what we talked about, but it's, again, it's a lot on you, Paul, but it's just gotta be done. I don't know any other way to do it.
Well, I think seeing the list will help. See what kinds of properties there are.
But it's not, it will help, yeah, but it's not gonna help what we're talking about right now.
Well, you
because-
categorize.
Right, but we're gonna say, you can draft category 1, whatever's there, this is what we're doing. Category 2, this is what we're doing. Category 3, this is what we're doing. This is where, for parks, there's a concession, you know, there's things you can do a lot.
So Richard, playing off of that, when you look at the next topic of definition examples of public purpose.
Yeah.
That is a whole nother section
Well, I
that
think that-
impacts.
Yeah, and how does that impact, because I know that was your, how does that impact the discussion that we're having?
Well, public purpose, I believe, should be a part, particularly if we're talking about P3s and other things being done. But, you know, the way the city is doing some of this licensing, the way it's doing leasing, and even maybe what the sale is something different. there should be a public purpose, and we need to define that. And I think Paul has taken a good first step at it. But as we heard last time, there's, the Code of Federal Regulations says a definition of public purpose.
I have that.
And the courts have it.
Yeah,
Courts define public purpose, then it shifts over time too,
it does.
you know.
So the CFR actually found that.
Because when they're doing some of these agreements for 50 years, they throw in the language of, for the public purpose, we'll build the park, but then you don't get the park. So does the
That's what
public
I-
purpose
yeah,
exist?
Not to be go through, that's just bad negotiating and bad. It's not, you
So
don't
under-
pin people down and in these documents and make them do what they're supposed to do.
Under the Recreation and Public Purposes Act, there's in the Code of Federal Regulations, public purpose means for the purpose of providing facilities or services for the benefit of the public in connection with, but not limited to, public health, safety, or welfare, similar to some of the other language. Use of lands or facilities for habitation, cultivation, trade, or manufacturing is permissible only when necessary for and integral to, i.e. and essential, the problem should be an essential part of the public purpose.
Where does this public, okay, let's talk about the structure we're talking about. It's got to go to the voters. If the voters approve it, even if you and I don't think it's a public purpose, the voters do, and that's.
Oh, absolutely.
So category, okay, category 2, if we're selling property. It doesn't look like a public purpose. We just gotta get rid of it.
No, under a lease or a license.
Okay, so we're talking about public purpose based on the lease or election. And let's say the city doesn't need property. They don't need it. And let's say the city hall property. They say, you know what, we don't want to sell it. But somebody wants to do some development on it, we'll lease it to them for 50 years and they can put in whatever they wanted in. Does there need to be a public purpose for that?
I think so, because what you're talking about is land banking. But again, you're just choosing a developer and you're allowing him to, I understand that the city commission votes on it. But if you're gonna lease public land, there should be a public purpose behind it.
Is
If you-
public purpose land banking? We don't know where, we don't need it right
Yeah, but
now.
I don't think that,
I don't think that's a
I don't
public
think that means
purpose.
a public purpose. That's just a financial decision.
Okay, so the public purpose definition comes in only on the leasing side,
And licensing.
right? And the life, you're not gonna use that word licensing, but whatever, we're gonna fix this up. Whatever that thing is, so that's where, so if they're gonna lease it or license it, whatever, it's gotta be a public purpose.
Yeah, I think so.
Last question.
That's correct.
Yes.
So if you're talking about public purpose, wouldn't you want that to go to a public vote?
Not in all circumstances.
But we're talking specifically, some of the big properties here in Fort Lauderdale that are somewhat controversial. And it never went to a public vote, it went to a commission vote. And I would say maybe we might be divided. But you wouldn't know until you actually brought it forth into a public venue and you had a public vote. My type of licensing, or I'm sorry, lease it.
And again, I think where the line between categories 1 and 2 is drawn is gonna be critical here. Because there is gonna be a point where it is not a matter of degree, but a matter of category. In my mind, there are probably going to be opportunities to lease public land that for a supermajority vote really should be sufficient. Otherwise, again, I think you are scaring off the top tier of developers that are going to be able to do the best work there. Because again, if your entire project is contingent on a referendum, why bother?
Well, that's the trade-off. The trade-off is the protection of the property versus maybe scaring some people off. Yeah, we have to sort of figure out where, where the line is. Some people would say, you know what, it scares off some people, it scares off some people. Anytime we lease public property, we're gonna put it to referendum. On the other hand, people say, well, we really need the development and it really enhances the city and it'd be really great in the downtown, blah, 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 blah. And we can't go to referendum meetings. I'm so scared of these guys.
So is there a bonding requirement that has to be posted in order to do that?
Depends on the negotiation. Depends on what you put in the, you know, sometimes there's a letter of credit needs to, you know, like if they promise that they're gonna do some sort of development. And you're concerned, that, which you always are, that they're not gonna do what they said they're gonna do.
They usually have to put it
They have a letter of credit, and if they don't do what they're supposed to do, there's you execute on the letter of credit and they don't
Because the
want.
city hasn't been doing that either.
But we're going back to the leasing though. You know, if you're talking about a 50-year lease, that's one category. If you're talking about a 1-year lease, that's.
I was thinking about that. Maybe there should be subcategories in the leasing area. You know, if it's a 1-year, if it's a lease of less than 5 years or something like that, non-renewable, maybe you make it so they can't. Less than 5 years, it just requires a city, but more than a certain number of years.
I agree. I'm just following up
Yeah.
the suggestion. We don't want to roadblock all leasing.
Right.
You don't want.
And Harrison, you raised the issue before with Margaritaville.
Right.
And I remember that
Most-
well, and, you know, you probably followed that one as well.
Until I got on here, I didn't read any Fort Lauderdale news, so I don't like it.
No, that was the Hollywood Margaritaville.
Oh, yeah.
And at that time, as you said, the argument was they needed the 99 years for the financing of the
Right.
deal.
Well, that's okay.
That's why we have a question from the public.
A real quick question. If you put that limitation on for the 50 or 90-year lease, and you say that we have to have a referendum, you're basically going to shut it down. Because very few developers will ever move forward and say, and get tied up in it, number one. And number two, what will be the cost to the voters for the referendum? Or will the developer, which there won't be any that will do this, will they pay for that? I think those things also should be considered.
It's a trade-off.
So Richard, when you were talking about in the city of Miami and that process
Yeah.
versus the process here, they've been able to deal with the financial.
I mean, I don't know who paid for the referendum, but I suspect the developer did. You know, that Inter Miami paid for the referendum, or two of them. I think.
They paid for that, they paid for everything.
They paid for, yeah, and, but I don't. Maybe,
They
you know,
probably
maybe
taxes,
5-year leases are super majority, and anything over 5 years goes to the voters. That's somewhat radical, but that's another way to, this whole public purpose thing to get eliminated, because voters say it's a public purpose, it's public, but maybe it's 5 years, or I don't know. That way.
I like what you're saying. I think we have to work on
We have to
the
think
time
about it,
periods.
yeah.
As to,
And,
But
you know, this wasn't the first time.
But Jackie said is that she's right, which is the trade-off is that you could scare off some developers for these PPP, you know, public-private partnership. And that's the trade-off. It's more important to preserve the land. Or to get
It may assist the city getting some serious proposals from people who have the financial wherewithal to even do the business plan for the deal.
Right. I worry again, if you scare off the competent, you're left with the incompetent. And again, I'd like to pick on my fixed base operators here at the airport. Those are long-term leases that.
A lot of times in these charter provisions, they have a
That
separate
point 30
section
and 40.
for the, like, I don't know where other unique facilities are, but you know, the airport, like Miami Airport, there's a whole separate section dealing with Miami Airport, because it should be separate. I mean, it's meant
We
to have.
do, we
yeah,
have a
that's
whole
one here.
separate section in here for FXA,
Yeah,
which needs to be
yeah,
addressed.
so that's what we should do. with these.
And again, I'm just worried that there might be, because again, this is a limit of my own knowledge, aspects of city property where we are encouraging private companies to sign long-term leases and improve their property. Like that's the entire point. That's just literally the one that I see out the window. Can't have a better example, but I know that just in my gut, there must be some way in which that is the mechanism by which the city is using its property to
What
generate.
did the city do for the, did they build a hockey arena at Holiday Park? Partner with the Panthers. So that would pay
The Panthers, Park Place, they all had to pay fees that the city did not get from Tucker State. So
No, but I mean, who paid for the, I assume there's
Kansas paid for a chunk of the renovation of Memorial.
And who paid for the, is there an ice arena there?
There's gonna be 2 ice
Who paid
rinks.
for that?
Yep, the Kansas paid for it.
Kansas paid.
Yep, just like Inter Miami, they paid for the entire.
They're also.
yeah, except the difference is it's Miami City.
Was that Anthony?
gets
They're
used
rehabbing the
four
whole
days out
Memorial
of the year.
Auditorium as part of that agreement.
That was important.
No, it isn't. Read the agreement. Yeah, read the agreement. 4 days a year.
The ice stadium. Anthony,
You
you're
haven't
familiar with
read
the
the
ice cream
agreement.
stadium in Miami?
Not really, not enough to really comment on. I get it wrong.
Straight High School.
They-
Aaron,
they-
Aaron, I would come.
I'm not trying to. I'm not false.
Yeah.
Okay, so I think we're
4
good
days a
with,
year, the agreement. Come on.
I think we're good with this component. Anything else on?
Well, I think we need Paul to do some drafting.
Exactly.
And we need to do some thinking about the balance. We need to
Looking
do
for some interns?
We need to do some thinking
No,
about
I'm
the
not.
balance that we're talking about
Let's
between
go on
protecting
to,
land, encouraging development, and where the priority is. Maybe it's the length of the lease, maybe it's that two-step process for leases, where there's up to a certain number of years. I'm.
If a developer wants to go 50 years, then he should have the wherewithal and the substance to.
Absolutely.
And it also eliminates the small public purpose discussion.
I'm alright
If it
with
goes to
scaring
the-
people off.
If it
Yeah, I don't
goes to
think
the-
it is still like.
I'm good with that.
If it goes to the voters, they've determined it's a
Yeah,
public purpose.
exactly.
You're only left with this public purpose issue if we do on the first increment, the group, the less than voter approval thing. So maybe there you try to put it there, but
Madam Chair, before you move to the next thing, just real quick, I checked with the procurement manager. They don't take minutes, but they are recorded. So I didn't want anyone to leave here thinking that,
Recorded audio or
Yeah.
visual?
I'm assuming just audio.
just
I don't,
video and no cone of silence,
I'm sorry?
and no cone of silence.
not that I'm aware of. Yeah, and just to finish off, well, did we get public input on the city election, this whole city election issue, because we sort of skipped over it?
I think the really thing that we need to do is just start making it more consistent with state statute.
I think we made some progress on the election issue. I had on the agenda public input, I just on the elections. Then I had decision as to whether we need change in the area of city elections. I think we discussed that. Okay, we have this conflict with interest issue, we didn't want to put to bed last time, so I left it under unfinished business. We have the opinion now from this. Are there any more issues? Because we can talk about, you guys talked about travel, commission travel and ethics, this and that and the other. Is there some charter change that we wanted to talk about with ethics? Do we need to leave it as unfinished?
I
business,
think
or-
that basically the county's ethics ordinance just needs to be followed. I mean, the ordinance is already in place.
That was my impression that
Yeah,
people just.
I mean-
need to be-
And I think that's what we said last week, you know, they need to file
Yeah.
and
Is
do
anybody,
exactly what the
is
state.
everybody okay if we take that off? The unfinished business?
Now, county for elected officials, right? State ethics for employees.
And that state also has.
And what?
Elected.
And the
also state.
And then also.
Yeah.
We've
The
got.
public voted
Yeah.
for that and it's already incorporated in the county charter, it just needs to be followed.
That's all. I
And
got.
the gift disclosures and all that.
Last thing was just general public input and then discussion of what we. do.
So, Jim, you want to start with?
Well, we cover all at once tonight. Discussion of city elections. Yeah, I think so.
It's like our 3.0, eliminated that. It's like you're. 3.0, then you're on.
It's gonna go through it and draft it. That's pretty good. I need to change it. It's to include the agenda. There's some other sections. You know, maybe some tweaking. We can go through them.
And I think you've certainly covered, the idea of leasing or selling public land. My only comment brought up the idea of taking it to public land, something lease, put it to a vote. My thinking was, it takes it out of the political, public land. And if it does discourage the developers, and I don't really think in the case of Fort Lauderdale, it's gonna discourage any. I mean, the developers are coming here because it's a risk reward scenario. If they see enough rewarded, you're gonna get top developers coming, they're gonna say, I want it, it's high. Little guys are gonna say, it's not trouble, it's not working. So that's my, I think it might be really considered.
Because we're gonna have that argument, the dividing line between things that needs their referendum for leasing and not, it's gonna be our part of the draft.
By the same token, when we're talking about city elections, taking a question out of qualification, or there's someone contest the results of the election, taking it to the court, or just taking it to the commission. I think it's a much cleaner way to do it. Takes a lot of finger pointing out of the process. So I concur with that. I think that's really the best.
Take very good. My gut is that if we just deal with, we don't have any new topics, we just come back with all the stuff that all this stuff that we're doing. Go over and make some decisions on those things, or that's enough to me.
One other thing regarding the lease of public property. Long-term 50-year versus 100-year. I'm sure there's a clause in there, or there should be, as far as reevaluating at the end of the 50 years. In terms of the new value, looking forward another 50 years.
Well, that's what we discussed. If you have a
Right.
50-year lease and that's it, then at the end of the term, other people will come in and it starts all over.
What did you think about what I suggested, that it cannot be renewed earlier than a year before the
Encourage
expiration?
to be able to be renewed.
But also, that's the camel's nose of the trend, that everybody will say, well, okay, let's just talk about renewal, and it's going to discourage other people who might want to do something with that same piece of property.
Because it wouldn't happen until 49 years later.
You know, what we're talking about is whether if somebody wants to renew it, that's fine. They need to then notify the city that they'd like to renew it. And we're talking about basically opening it up and saying, okay, this lease is going to be renewed for this. Anybody else want to come in and put in a proposal? We're talking about opening it up and creating a competitive opportunity for the renewal.
I think your wording of that 1 year gives a advantage to the person or leaseholder. Interest person to say, well, I have the right to negotiate first.
That was just one idea,
Yeah, no,
for lack of.
yeah, but we talked last time, let's just have a clean break, 50 years. That's it. No exceptions.
You also want to make sure if someone does come in for the renewal, they don't then have the legal right or the ability to flip it to somebody that wants it more. And then they get the profit and the city
Well,
gets.
that's all in the draft.
Right,
Can't be
that, I
transferred.
know, but it's
When you
just.
said
some of
the
this
major
stuff that happens.
projects, you've done down to
The
Miami,
AMR.
Yeah.
They're flipping
when
it.
you've done the major
Exactly.
projects down in Miami,
That's very.
how does that work when, whether it's the heat arena, whether it's the car rentals at the airport? I mean,
You made a renewal.
Mhm.
Well, we just renewed the lease for the heat, the operating agreement for the heat. It was not a competitive process. Most of them have not been. Joe Robbie, maybe it was a 99-year lease. Something they do. I don't remember Monday Power Plant. That's a long term lease they renewed it. I don't think there's a competitive provision built in that says they have to go out. They can, but I don't think there's a competitive provision built into the ones that I would never put it in. But I don't think so. But I don't think it's such a terrible idea from the city stuff.
Well, I also heard the anti-flipping idea, and that's,
But that's just a clause in the contract. This contract cannot be assigned, transferred, blah, 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 with the approval of the city. It's just one
You can,
sentence.
yeah, you're gonna have very few large companies coming in
So,
to lease property that are only gonna get it for 49 years and not have that ability. And maybe that's what the end goal is, to prevent this from happening too much, you know?
Yeah, what is the end goal?
Yeah, exactly, but I think it's almost like, I don't know.
Is there a provision? That when you do lease property, a large city property, that there's a dollar threshold associated with the appraisal? As opposed to just letting a $1.
No, I don't, no.
Should there be?
Meetings letter questions, so.
I want to lease. Lockhart. A big developer, I want to. And I get the lease for $1 a year.
but won't be acres.
Right, what we're talking about is at least we have to do the voters.
But how do you appraise something like that?
Well, you can,
You can.
Yeah.
you can
I mean,
because.
certainly $1 a year is a pretty good price, but I mean, I'm just, how do you do that?
Now, that could be offset by revenue share.
I don't know if you ever followed back when Lockhart State, when it was Stryker Stadium or the Orioles. And how that was done. And the there was a major, there was a lot of money that had to be utilized, and it ended up being a county and city joint agreement because the county ended up assisting as well with TDC funds for it.
And there's also state money.
It's really a matter of the city commission negotiating a deal and then putting it to the voters. But for instance, like for Joe Robbie Stadium, the county was very interested in getting, they want getting that property developed. They leased it to Joe Robbie for $1 a year. And so that was a good deal. They got Falcon Stadium, and maybe some people think it's good or bad, but they wanted to get it done. But I think this, the safeguard, if, and the longer lease is going to be, it's going to the voters. And if the city commission got a negotiated deal, it goes to the voter and the voters don't like it, people are going to open up their mouths, that is a bad deal.
And then you don't really have to worry about this whole thing about public purpose, because the voters are gonna determine if it's a public purpose.
Yes, I think we've limited the use of the public purpose issue to that period of time undefined between a short-term lease. And that's what we have to talk about.
Jim, it's like for the
Harrison,
water
you should
treatment.
take a look at the issue at the county Esper Drew, it was the year that Lois was the mayor.
2008.
When they did that, when they did that agreement here with the Orioles.
Jim, for the water treatment plant, as an example, we had multiple bidders, right, come in and say, oh, they don't want to do it, they're interested in doing it. Then we had an independent third party, Ernst & Young, that came in, evaluated all of the proposals and how this will provide, in effect, an appraisal of what's. And again, when we're
But-
buying property, cities buying property, you're required to have a certain number of appraisals, and you can't pay above
Well,
whatever
that's
is the
what we were talking about
median.
before,
Right, let me just finish up the median appraised value so that, you know, a certain percentage, so that no one's getting a sweetheart deal.
but
Where
the
is that?
problem was
So
that the
that's-
city sometimes,
that's in
when the
the-
outside
Sorry.
force comes in and said, a business plan isn't there and the financials don't work, the commission would override them. So,
Yeah, I don't know
which is
exactly
what
where
they
that
did
is.
with One Stop and with Lockhart.
It's on the charter. I'm
They
guessing
didn't
it's on
follow
here.
the,
I'm gonna be in the charter.
they did not follow the recommendations of the lack of business plan.
I think we have more public comment.
I just had one thing I want, it was brought up in the beginning and I'm not one of Ben's people. For the record.
No one wants me described as such a pejorative.
They have to be clear that Jim and I are here from the Council of Fort Lauderdale Civic Associations. Nobody owns us.
That's
right.
We don't even live in his district,
Yeah.
so.
But this is important. What I'm gonna tell you is that in the beginning, when we were talking, Ben brought up the idea about lobbyists that currently lobby the city of Fort Lauderdale not being appointed to city boards. It's a big deal. Just to give you an example. Joanne Robinson, Harbor Inlet President, against that. Annette Ross, Harbor Beach, Estelle Brennan, Riverside Park, Nancy Long, River Oaks, Melinda Bowker, President of the Downtown Civic Association, Wendy Wills, Edgewood, Earl Prisley, Lauderdale Isles, Catherine Moss, former chairman of the Planning and Zoning Board, Brandon Cox, Joe Feldman, president of, what's he?
Beverly Heights.
Beverly Heights, Lynn, I mean, there is Vanessa Popiker. People care about this, and it's an issue that's very, very simple and obvious. So I don't know how you all can deal with it, but it's something that, it shouldn't be happening.
Okay,
And
thank you,
hopefully-
because I think then that you need to, since this is not a board that has any final determination, it's a board that gathers and advises and then goes to the commissioners, and the commissioners then turn it to the voters. So it's a board that makes decisions based only by the voters making the decisions, not the board, unlike the DDA.
Well, the
unlike
DDA, they're
task
getting all
force,
fairness,
unlike
is,
all of these other boards. Jackie, you have been on this personal vendetta and bring this up constantly at meetings. And you leave out the fact that these meetings at HOA stuff or district meetings. And it's an issue that is fascinating because they only raise the issue when it comes to the Charter Revision Board.
not
So
true,
if you
honestly,
want, so
not
if you
true.
want, then you have to take a look at the Planning and Zoning Board. And you have to think as well about people that serve on the other boards. And this was discussed at the commission, all the other board appointments, whether it's the Broward Center, whether it's P and Z, whether it's nuisance abatement, whether it's the economic development, et cetera, et cetera, et cetera. And in fact, Glassman's appointment to this board prior to you, Harrison, was a registered lobbyist, a land use lobbyist.
Who was that,
registered.
Jamie? Who was that?
Take a look.
Jim
her
Ready
name?
retired? No, not.
No.
Anyway, I don't want to talk about what happened and what didn't happen. I think as a city, the people that I know that are leaders in this city do not want paid lobbyists that are lobbyists of the city of Fort Lauderdale being appointed to boards. That,
Okay,
and that
so
issue
let's-
needs to be
let's
brought
move.
up.
Then you have to take it to all boards,
Correct.
all-
This is
all
a charter.
appointments.
This is,
all
I
appointments.
is
think we
not-
talked about that before, when we come to that particular section of the
Right.
charter. We put it out to the public and see what
and
they
it,
say.
right, and I just, I came here to discuss that because it was on there, Chris. So and these people
Yeah,
asked me
well,
to speak for them and give their
I've
name on
been
the
in-
record.
I've
So that's
been-
why I
I've
said,
been-
I've been in
I'm
district-
fine. Yeah,
I've
I'm
been in
fine.
District 4
Fine with it.
meetings, pre-agenda meetings, where you chime in and you only attack me on the Charter Review Board and name me in your attacks.
No,
and I don't think that this is
Chris got the
appropriate.
fair point,
Absolutely.
which is, this comes up, somebody will, if somebody wants to,
Right.
they will make a motion to say that we want to tell Paul, because he has no work to do, to draft a provision that prohibits lobbyists from serving on city vacation.
And I don't even know if it's really an issue, Mike, to be honest with you, for this, or is it
Let
issue
me
with
just
changing?
let me
words?
just finish what I'm saying.
And
So I'm
I,
saying is,
again,
for this,
it needs
for
to
this
be-
board, when it comes up, somebody will either make a motion or not make a motion to include this in our charter recommendation.
and I
You
also
will-
think,
Judy, you will get a second. And we vote on it, Paul will draft it. If not, you gotta go someplace else to get it done.
Right.
And that's fair.
And ultimately, it's gonna go to the city anyway.
Ultimately, yeah, but the point is, if there's a majority of this board feels like it should be here. Then it'll go with our recommendations. If not, then you're gonna have to, then you've tried here and you go to the city. But you're gonna require 3 people on this board to include it in our recommendations, and that's it. I mean, I promise you that I will, that I will listen to it, and when we deal with it, just like Chris said, when it comes up, we'll deal with it. If somebody makes a motion, that's great. If not, then you gotta go someplace.
Well, there's other things, I mean,
No, I'm just
You guys
talking about
do a
this.
great job,
You're
so I
concerned
appreciate
about
you
it, so I'm trying to address it.
all right, so the next meeting, we are going to each topic.
Yeah, next time we're gonna
Second
deal with all the work.
And just to follow up, Chair, the topics I have for next meeting is the list of city property that's requested. We're already working on that. Thanks, Anthony. Anthony's already doing the work. The
No problem.
email already drafted to staff, staff working on that. draft charter language on regarding leases? Are we still doing that?
But Paul's got a whole, Paul, you have a list of things you need to draft, right? Paul, you have a list. Paul will give you the list.
Paul will
You're
give me a
already
list.
drafting, you and I'll look at it, make sure that,
Okay,
yeah.
okay, all right.
City commission is taking a break. Are you taking a break?
They're a break till August 22nd. Are you saying that we should skip August? Is that what we're asking?
That's what he expressed.
Like a great.
I'll get up to Kansas.
Paul has a Kansas approved. City commission.
Meetings around the city.
The,
I don't have anything planned, unfortunately.
along those lines,
Commissioners have our board meetings.
it's just me, but August 3rd, I'm on military duty overseas, so I can't be here physically. So if it could be delayed, that'd be great, or if I can.
What would naturally be the next meeting date?
August 3rd.
Oh. What is that?
It's a Thursday, the first Thursday of the month. I get back from military duty the 5th of August, but if that matters.
I think we can move it to the next Thursday. if that doesn't-
I have scheduled, I flew in for this meeting. I'm
Wow.
scheduling my meetings in Fort Lauderdale around the schedule that we've set. And so, like the attorney selection committee, I'm having it scheduled, so it would be hard for me to move it. I'm fine with skipping it, but it's hard for me to move it to a different day.
Perfectly fair.
I got joined in with Richard. We planned our summer vacation so we could include the 3rd. So I also agree with Richard. If you want to skip it, that's fine, but moving it to mid-August would, I think. Impact. Yeah, impact.
Whatever you all like, it's great.
I will make a motion to skip the August meeting and we will reconvene on September 7th, which I think is adequate time to.
Yeah, that'll give you a little more drafting. But I'd like to get the agenda out early. Right? We don't like.
You guys work so long.
We don't like the way into that.
But
Yeah, me, and Mr. Weiss have a, yeah.
We got a deal going.
Deal going. So,
That kind of
is there a
stuff.
second?
Second.
All in favor, moving.
No, he moved.
Okay, second, okay.
All in favor?
Keep it unanimous.
All opposed?
so that means that your next meeting is September 7th? Yes. Well, deadline is still next week.
Yeah. I did-
No,
I just need a list of what you're drafting. That would be great, so we get. Fine.
Has the meeting adjourned? Or is the meeting-
I got up, I thought it was real.
Second.
Perfect timing to rain and stop.
Yeah. There's a light rain. Yeah, light rain might be coming probably.
Conference meeting yesterday.